relevant portion of reference, my lord should have that it.
Yes.
Yes, my lord.
So if it's on the short point of 107, these three orders, my lords will
So
have.
submission is only on 107.
107, my lords. I don't have to touch the merits or anything else if 107 is not complied with.
Yes.
Your Lordship may see the ground on which the Sessions Court allowed the application filed by the respondents. Solely that there was a confusion about applicability of the
The order
banning.
that I passed.
In spite of Your Lordship has passed an order and held that it is applicable, trial court went to the extent of saying that there is a confusion about this thing. Therefore, it has been enlarged. It is not that we are not complied 107 or 106. 107, my lord, I have a different argument.
107 held, buddy. It will see.
With
Yes.
107, my lord, may I request the first judgment which the senior counsel relied on, my lord. Kerala High Court judgment is what they are relying on.
Yes, sir.
Your Lordship is some little background, my lord.
Of Kerala High Courts.
Kerala High Court and 106 and 107 together. That Your Lordship will see in para 3. This is the argument put forth by the petitioner before Kerala High Court.
Yes.
In page 2, my lord. Section, Your Lordship got it, my lord.
Yes, I am there.
The following contention. Section 194 and 106 BNS does not empower the police to seize/freeze the account of third party, while section 94 has no application. Section 106 would apply only tangible properties which are believed to be stolen or found under circumstances which create suspicion of circumstances of an offense. So it is not, we are dealing with a third party, we are dealing with a first party. And it is not the case that 106 has no application at all. That is what the senior counsel relying on, my lord. But before that, my lord, para 6, where Supreme Court initially held whether bank accounts is a property or not a property. And
Tapas
Singh. Tapas Singh has been extracted. The only reason for reading Tapas Singh, my lord, to see what is the purpose of section 102 has been extracted in Tapas Singh. Para 12 of Tapas Singh, my lord. It says, we are therefore persuaded to take a view that bank account of the accused or any of a relative is a property within the meaning of section 102 of the Criminal Procedure Code, and the police officer in the course of investigation can see the property, can seize or prohibit the operation of the said account if such assets verdict link with a commission of an offense which the police officer is investigation into. Then the last paragraph of that, my lord. In the aforesaid premises, we are of no hesitation to come to conclusion that the High Court of Bombay committed an error in holding the police officer do not have seized the bank account, etc. All this is what the court has held. Now, 102 has been extracted. It is not that, my lord, 102 has been deleted from the BNS after BNS came into existence. 102 exists in the form of 106. 106. Now, 107 new provision has been inserted in BNS. So, therefore, the contention is 106 has no applicable. Only 107 is applicable. Now, Kerala High Court, in fact, did not say that. Your Lordship may see para 13, page 8.
Yes.
Para 13, my lord. Another aspect of importance is that while section 106 speaks about seizure, section 107 deals with an attachment. We are not an attachment. We are only seizing the bank account for the purpose of investigation. Forfeiture and restoration. 107 deal with the attachment, forfeiture and restoration. Seizure under 106 can be carried out by police officers and an ex post facto report submitted to the magistrate. This is virtually what 102 speaks. On the other hand, attachment under 107 can be effected only
on the orders of the magistrate.
We are not on 107, we are only on 106. So 106 is not taken away and 106 continue to be exist. So therefore, even Kerala High Court did not say we cannot seize the property under 106. Now we come to, with respect to Karnataka High Court judgment, in fact, no, Supreme Court did not interfere. Saying the peculiar facts of the case, they have not interfered. We are not, I will go with the Kerala High Court judgment, my lord, and say that 106 is what we have dealt with. Our High Court judgment, my lord, at page 10. 4 questions have been raised. Your Lordship will find that questions raised in para 26.
Para 20.
Para 20.
Yes.
The first question is whether an action of respondent when directing debit fees of the bank account pursuant to communication dated so and so in connection with crime number is sustainable in law, particularly when petitioners are not arrayed as an accused in the said crime or in charge sheet filed therein. Second question, whether impugned action of debit fees is vitiated account of non-compliance or mandatory procedure contemplated under section 107 of the Bharatiya Nagarika Suraksha Samhita. Now, this is the case where charge sheet was been filed. Investigation is completed, charge sheet was been filed, and they are not an accused people. So this court said, once the charge sheet has been filed, you cannot come back to 106 because 106 is only for the purpose of investigation. 107 is for subsequent investigation. Therefore, neither the Kerala High Court judgment or the coordinate bench of this judgment or the Bombay High Court judgment deals with the issue of 106 where investigation is pending against an accused person. And what we are dealing with is only against investigation against an accused person for commission of an offence. Therefore, my lord, 107 at present has no application in this case. With respect to 106, my lord, we have seized it and we reported to magistrate immediately.
That reporting is.
That has been done. So therefore, they cannot come up and here and ask and say that virtually, my lord, the argument of London Senior Counsel is make 106 as redundant for the purpose of investigation. That I think, my lord, cannot be accepted.
Yes,
And more importantly, two aspects I want to bring to your lordship. The challenge to the dismissal of 482 was taken to Supreme Court. In that SLP, an additional documents have been placed before the Supreme Court. Your lordship may see what all has been placed before the Supreme Court.
ಇದ್ರಲ್ಲೇ ಇದೆಯಾ?
ಎಲ್ಲ ಇದೆ ಅದರಲ್ಲೇ ಇದೆ. Page 4, my lord, speaks about your lordship's order of peace order. Page 4, my lord, para F.
Yes.
The state thereafter preferred to challenge the order dated so and so. This is what been pending, my lord. By a criminal petition so and so, by order dated so and so, Honorable High Court have directed not to be released consequent of the order of designate court. So the order of your lordship in staying the operation of district sessions court order is also placed before Supreme Court. And more importantly, my lord, pendency of SLP, pendency of this petition before this court, they have continued to open a new account without even disclosing. Neither they disclose to this court nor disclose to Supreme Court.
Which is that new account?
We have that also. We have frozen, my lord. Unfortunately, that they've gone on a GM police and got a stay on that also.
Which is that account?
It's an existing account.
Where is the stay order there?
Existing account.
Stay order. It filed in GM police.
A new account open ಮಾಡಿದೀರಾ?
No, my lords, that's not frozen. What was in existence is frozen, and that is against the parent company. Parent company in vacation filed a writ and interim order
That is what
granted.
day before yesterday.
Yes, my
Same
lords.
thing.
Same. That is what they tried to say. It is the parent company. Their account was frozen. Writ petition filed during vacation, and on score of 107 not being complied with, stay granted. And at the same time, they tried to invoke KPID.
Now,
We approached this.
whether freezing of the account would amount to an
Yes, my lords,
attachment.
I will be
amount,
able
that
to.
is the only clarification I need.
Absolutely. Right.
Whether freezing of the account
Debit
would amount to
fees.
attachment of property.
My lords, right from the first judgment, let's see it, my lords. Kerala. I'm sorry, if
Jagdish sir,
Jagdish
ಆಯ್ತಾ?
has finished.
ಮುಗೀತಾ? ಇದಾ?
Can I?
Yes, sir. Those three accounts which there in the bottom.
ಜಾರ್ಗೋಲ್ಡ್ ಅಕೌಂಟ್ ಅದು?
No. That is what, that's the parent
Account
company.
opened after the SLP
My
dismissal.
lords, can I give the details of
Give the
all the
pendants.
accounts?
Is the
My lords,
pendants-
can I give details of all the accounts? If it has to, I'll answer the accounts, my
now-
lords. Now, the first point is whether debit freeze amounts to an attachment. This will be the main aspect, my lords. My lords may kindly have
No,
the,
1 minute. If debit freeze is an attachment, then 107
107
becomes
comes.
applicable.
comes in.
Correct. Then
Yes, my lords.
debit freeze is an attachment. Then
107.
106 becomes
That is-
inapplicable for the purpose of
106
investigation.
becomes redundant.
Redundant. So therefore, the earlier judgment.
Now,
my lord-
earlier freezing was happening and reporting under 102. Correct?
Correct, my lord.
Now it is to be reported on 106.
Correct, my lord.
Then if 107 says attachment of the freezing of an account is an order of attachment, then 106 is
Redundant.
To that
The-
extent.
the- That's where, my
That's
lord, that earlier
exactly the
judgment where
interpretation.
bank account is the property been held by Supreme Court. Supreme Court interpreted 102 and said even the bank account can be frozen and then intimate accordingly. So 107, my lord, has come into existence pursuant to this ordinance of 1946, which was there earlier, limited the extent of freezing of attaching of properties of certain properties. Now that is extended to the in BNS.
ಅಲ್ಲ, 107 BNS ಅಲ್ಲಿ it is not freezing of account and explicitly ಹೇಳಿಲ್ಲ, it's attachment ಅಷ್ಟೇ.
Can I just explain it out, my lords? Now, in BNSS, the reason for bringing in 107 is, my lords, the power that the investigating officers were exercising in doing all kinds of attachment of various aspects, they felt there should be a check and balance. Now, the check and balance they have brought in is, you get the order from the magistrate before you do it. There again, my lords, two aspects they have dealt with. One is, my lords, the magistrate would give an opportunity to the person who gets affected before passing an order of attachment. Now, again, the law would say in an event that it will not serve the purpose, you can pass an ex parte order. These two protections have come into section 107. Now, my lords, kindly notice the Kerala High Court case of debit freeze. If my lords would have the very first judgment, Headstar Global, please notice in paragraph 2, the essential facts as under, please go to page 2, my lords, just above paragraph 3. The investigating officer issued Annexure B notice directing the bank to debit freeze the petitioner's account. My lords, gets that portion?
Yes, yes.
Now that is assailed. Now the court goes through section 102 of the CRPC, then it touches upon section 106 of the BNSS, and then at paragraph 10 comes to 107. Could I request my lords to notice page 6, paragraph 10?
Yes.
Attachment, forfeiture or restoration of property. When a police officer makes an investigation, has reasons to believe that any property is derived or obtained directly or indirectly as a result of a criminal activity or from the commission of any offense, he may, with the approval of the superintendent of police, one line there, my lords, you need the approval, then make an application to the court or the magistrate exercising jurisdiction to take cognizance for the attachment of such property. If the court or magistrate has reasons to believe, whether before or after taking evidence, that all or any of such properties are proceeds of crime, the court or the magistrate may issue a notice upon such person calling upon him to show cause within a period of 14 days as to why an order of attachment shall not be made. 3. Where the notice issued to any person under subsection 2 specifies any property as being held by any other person, on behalf of such person, a copy of the notice shall also be served on such person. The court or the magistrate may, after considering the explanation, if any, to the show cause notice issued under subsection 2 and the material facts available before the court in respect of it, proceeds, provided that if the person so appears, he is able to answer back to it, my lords. Then kindly notice 5, my lords, where ex parte order can be passed.
Yes.
Subsection 5.
Yes.
Then, my lords, after that, please notice now paragraph 12, debit freeze. Paragraph 12
Yes.
at page 7, going by section 107 of BNSS, a police officer investigating a crime has to approach the jurisdictional magistrate seeking attachment of any property believed to be derived from so and so. And then, my lords, kindly notice another aspect of importance is that 106 speaks of seizure, 107 deals with attachment, forfeiture, and restoration. Then paragraph 14, in the case at hand, reason for directing the bank to debit freeze the petitioner's account as noticed is Annexure B. Notice is a transfer of some amount in so and so, and they set it aside, debit freeze. Now this, my lords, is taken up to the Supreme Court, SLP is rejected. Now when it comes to our court, my lords, at page 10, Muffin Technologies, again a case of debit freeze. And again, my lords, the second point was specific whether 107 needs compliance or not. The answer to that is in the affirmative. Now, if you want to do debit freeze, you have to get the order of the magistrate, my lords. What was pointed out was Roman 1 and 2. 2 is a complete answer to it, that you have to get an order from magistrate, otherwise you can't do it. All this is after 1/7/2024, my lords. Then the same view is taken by 8 other high courts, my lords. Same view, that 107 you have to do it. So now trying to distinguish, my lords, in our case does not arise because it's a case of debit freeze. Now, my lords, when it comes to a case of sealing the immovable properties, it is covered straight away by the Supreme Court ruling. You can never seize an immovable property. It doesn't come within the scope of the power of the investigating officer. On any score we look at it, my lords, on violation of 107, the 3 orders which were passed by the investigating officer goes, my lords. Now added to it, my lords, gave us also a liberty, my lords. GST, we were unable to pay it. My lords felt right to the IO, let the IO take care of it. IO wrote to the 3 banks, my lords. 2 banks on that basis permitted us to withdraw the amount. Third bank,
clarification.
yes, my lord, that because they were under the impression KPID Act, even that was state. Once you have BUDS-Act, KPID Act doesn't come, is the view taken. So in all respects, my lords, the order passed by the learned trial judge is justified. And my lords, a small confusion. Kindly notice, my lords, one small confusion. It is not that the trial court tried to interpret my lord's order. Now, please notice what the trial court did. It considered the matter 1 month after my lord's order. It never clarified my lord's order. Please, can I just point that out, my lords?
That's all right. Wait.
Just one
So
point.
now 106, 107.
No, there's one issue, my lord. That coordinate bench judgment, my lord. I'm sorry, my lord, that we have not apprised the bench with respect to 106 at all. Your lordship may see there is no reference of 106 in that.
No, there is no
judgment.
reference, but 107,
No flaw.
point number 2 is with regard to debit freezing and compliance with 107.
Correct, but point number 2, compliance. Your lordship may see now scenario, my lord.
No,
Cyber
now you take a scenario. Now you go conduct a search somewhere. You find properties, so many things that are there. So you have to go back to the magistrate,
Magistrate.
seek his permission, and then seize it.
Correct.
That is one thing. All right. If it amounts to attachment 1, and the other thing is, if you want to debit freeze an account, you'll have to seek the permission of the magistrate. By then, account khali agidra.
Allah, the simple scenario, my lord.
Expiry
1097, I
order.
can make a phone call now and say that I have been frauded. Immediately, message will go to the bank. Bank will freeze that this thing. I can go back to a police station, file a complaint. If I file a complaint within 3 days as directed by this court and other courts, my lord, then it will be communicated and it will be completely frozen. Otherwise, bank will do nothing. The 1097 become redundant. I cannot even file a complaint. There's no point in calling them. First go and file a complaint, then
But
register.
all these cases are cases of
Cases
debit
of debit
freezing.
freeze. But, and also one clarification can I give, my lords? An investigating officer, when he's investigating it, he writes to the bank, my lords, you debit freeze. Now what the law mandate says, you don't write to the bank, you inform the magistrate. And magistrate has the power for ex parte. So even this apprehension in saying they may take away all that money.
Then
will
what
not help.
happens to 106?
My lords, 106.
No,
Anyway,
what happens to 106?
could I just point out, my lords,
106
106
is
also.
102
It's
of the earlier
equivalent to
regime.
102. It's equivalent
Yes.
to 102.
Yes.
But now, my lords, when it comes to attachment, which includes debit freeze, 107 is mandatory. It is mandatory. And that is the consistent view. Because, my lords, investigating officers used to write to, my
No,
lords, even
because
if the
you come to
crime.
Kerala High Court judgment,
Yes.
see the last paragraph. 13 and 14 forms the crux there.
Correct.
Para 13 and 14, if you read, in the case at hand, reason for directing the bank to debit freeze the petitioner's account is that they are proceeds of crime. So proceeds of crime, if you want to debit freeze, then it becomes an attachment under 107 is what the interpretation of Kerala High Court. So without that, it can't be done.
Great respect, my lord. Your lordship may reread para 13 once again. Para 13 has 3 elements.
Yes.
3 elements, according
Correct.
to me, my lord.
No, 106 ex post facto, you have to report to the magistrate. 107, if you have to attach any property
Right.
or whatever, so you have to take the prior permission of the magistrate. Like any attachment proceedings, you have to take permission. It's not, you can't straight away attach a property.
No, the
Now
confusion
this,
the confusion in para 13, my lord.
And
this,
this taken even
got
by the-
into a quagmire, no? Yes.
My lords, even the coordinate bench has taken that view, my lords.
Which one?
107.
Very good.
Coordinate bench
Justice
also. Yes, my
Magdum
lords.
Avradalva.
Magdum Avradalva.
Para 30,
And he
page
re-
32 and 33.
Yes, my lords. He relied on the decision of the Delhi High Court.
Correct, and head star.
It's
Because what is followed at page 35 is head star.
because, my lords, what was normally seen is if proceeds of crime is 10 rupees, my lords, the attachment that used to take place could be of 1,000 rupees, just debit freeze.
No,
Now,
correct.
it's
That
a
is-
safeguard which has been provided under the BNSS. And the object behind it is,
So, but how do you reconcile 106 and
but anyway, my
107
lords, in
now?
all these judgments, both 106, 107 were considered. And they said with 107, you have to get the order of a magistrate. And that is now mandate.
We have not gone on 107. We
How can they
are
say
going
this?
on 106.
Debit freeze, how can they do, my lords, if they're not going on 107?
Lord,
And these are cases of debit freeze.
The
As it stands now, my lords, this would be the law in my respectful submission. Till so long as 107 is there, you are bound to comply 107. If you feel 107 ought not to have been there, you challenge. As state can challenge that, saying it's not necessary.
Why we are
Validity of 107. If they're going to be questioning, saying the object will be defeated, no.
no. We are not.
Legislature
we are agreed to 107.
consciously has brought in
when we are
107.
attaching the property and a KPID, if you want to attach those property, 107 will be followed.
KPID, we will see that separately, my
KPID
lords.
separate, of
But
course.
this is under the BNSS that it's being done. If it's under the BNSS, 107 is a mandate.
The object, my lord, in Tapas case where the Supreme Court first time interpreted bank account is a property, they precisely the reason why they interpreted that manner.
With all these judgments, it
cannot,
becomes
in
very
that
tough
sense-
now, my
in
lords,
that
to say
sense-
that we have to interpret it otherwise.
No, it has to be interpreted.
Now, coordinate bench
Part of
also has
legislation has to be
interpreted
looked
it.
into. It cannot be that. It cannot be that, you know.
They may
my lord,
test
that we
the
ignore
waters in
106
Supreme
and-
Court, my lords, probably. If they want to test the waters, it could be there. But to say the object
but
could be
if
this
this,
object, I don't think so.
Submission is accepted and all the judgments followed. 106 should be taken away from the statute.
My lords,
book.
some check and balance to an investigating officer.
no balance.
Is exactly 107, my lords. Check and
So if
balance,
you want
because,
to-
my lords, one aspect of
I'm
investigation.
trying, how can you harmonize the
My
two?
lords, because one aspect, my lords, under the criminal jurisprudences, the supervision of an investigation is always that of a magistrate. In every aspect,
Correct,
kindly look
not a
at it.
problem.
Arrest of a
See,
person.
that is why
So they have
if it is
brought in
debit
that-
frozen, it should be informed to the magistrate. So the supervision goes with the
My
magistrate
lords,
only.
here to say debit frozen, you get the order. My lords, it's not something of a tearing hurry, as my lords felt. What
No,
happens if it is?
No, now this is
ex
one
parte?
this is one circumstance. Now the cybercrime center gets a call. They have a portal, gets a call saying, I've been defrauded of 50 lakhs, 60 lakhs, whatever amount it is, X amount. It has gone to this account. It is turned out to be fraudulent. So you'll have to go to the magistrate, register a crime, then seek his permission, then debit freeze the account. Now, once you register the crime, the accused is entitled to a copy of the FIR and all those things. Prior to that, you debit freeze the account, or you go to the magistrate with regard to the crime and then do it.
Whether they
But-
have the power to debit freeze without there being a crime. My lord, starting point of all this will be the registration of an FIR, my lords. That's the starting point. Otherwise, you can't have investigation at all. But
No,
not
by-
in the guise of saying, in an inquiry, I'm going to do
by
it.
the
That-
time, circumstance, of course, it's not an
Please,
illustration.
illustration.
By the time the crime is registered and the permission is taken to debit freeze, that particular account, the 50 lakhs that whoever the complainant has lost is vanished.
We can't.
No,
My
no,
lord,
illustration.
my respectful
I'm
submission.
only an
is-
illustration. See, the accused gets to know the crime is registered and debit freeze is to be done. He has to go to the magistrate. And by the time magistrate gives 50 lakhs was there in the account, it
My
vanishes.
lords,
Now, where does the victim
no,
go?
by the time the magistrate gives means ex parte, if he feels he keeps
Maybe
it,
ex parte he gives permission,
That is
whatever.
mandate.
By that time the account goes. Illy what happens is immediately debit freezing is done when cybercrime is registered with that portal. And that has become so rampant today. Now, if you have to go to the magistrate, take his permission, then debit freeze.
Probably, my lords, in the terms of lien, we will have to look at it. But debit freeze, no. We'll see that, my lords. Even in
No,
terms of lien, we'll
comes
see that.
later. Lien comes when quantity, when amount is quantified, yes, lien you mark.
That's the reason, my lords. Probably we'll see it, my lords, in terms when lien has to be marked or debit freeze. But debit freeze, definitely, my lords, 107 steps.
No, if any citizen would lose 50 lakhs or a crore by the cyber crime that is happening today, and ಅಲ್ಲಿ ಹೋಗಿ ಎಲ್ಲ
ಈಗ-
ಶಾಸ್ತ್ರೋಕ್ತವಾಗಿ ಮಾಡ್ಕೊಂಡ್ ಬರೋ ಅಷ್ಟೊತ್ತಿಗೆ
My
1 ಕೋಟಿ
lords,
ಖಾಲಿ.
ಈಗ, just take for instance that complaint is frivolous.
Sorry?
One, the vice versa, that
Vice versa
complaint,
also, no problem.
if it is frivolous,
No, if it
and
is-
just like that, a
if
debit
it-
freeze
if-
takes
no, no,
place.
If it, see,
both
now,
ways,
one
my
minute,
lords,
if
both
it is,
ways.
1 minute, if it is frivolous, what happens? It is defrozen, not a problem. But if it is not frivolous and real, if the money vanishes, what do you do?
Now, my lords, ಈ ಕೇಸಲ್ಲಿ FIR ಇತ್ತು.
ಅಲ್ಲ, ಈ ಕೇಸಲ್ಲ, illustration.
So the even in that illustration,
No,
my
because
lords, whether
106,
in the
106,
scope,
107, if you have to harmonize it or reconcile it, then the interplay between the two will have to strike out.
exactly
even
what
in
has,
this-
my lords, in my respectful submission, both the provisions have been looked into in all these judgments.
No, coordinate
Both.
bench doesn't look into 106.
My lords, even 106 and 102, comparison is there because 106 is exactly what 102 is.
Correct.
Added
It
safety.
is verbatim similar to
Yes, my lords,
102.
added safety came at 107. And legislature thought it fit to add that safety.
No, ಆ ಥರ ಆದ್ರೆ
Getting,
a victim losing money, where will they go ಅಂತ ಅಷ್ಟೇ. ಅಲ್ಲ, we're concerned about the victims also, not only the accused.
yes.
In case of jar gold,
With even Malabar Gold, my lords, which is there of Delhi High Court, that's also similar.
Because so
Cyber
many.
crime. It's
so-
cyber crime.
No, so many fall prey to cyber crime today.
This is cyber crime. Malabar
Correct.
Gold, if
All right,
seen,
no problem.
cyber.
I'm only asking.
Yes.
no, in case of jar gold, my lord, it's not just about money which is lying there. It is also about receiving funds from other victims.
Whatever proceeds of
preventing
crime, let's take it
By
that,
seizing,
my
you're
lords, I'm
preventing
not on the
other
merits
victims
of
to
the
fall into
matter.
the trap.
I'm not on the merits of the matter. Assuming it's
That's
proceeds
where
of
106
crime,
that's
even
where
if
our-
it's
our-
proceeds of crime, my lords, it says this is a procedure.
So
And
that's
you
where
have to
106
do it
has to
as
be
a
harmonized.
procedure.
It's
Now,
not
my
that-
lords, if it is 102 and not reporting to the magistrate, my lords would interfere and quash it.
Yeah, we are
102, like 106. But here, 107 is there where you have
No,
to
that's
get
what.
the permission
Instead
of the
See,
magistrate.
that also, a post facto
Fact.
information to the magistrate has not been complied with, we quash it. A pre-incidental permission is not taken, we should defreeze it or whatever.
That's exactly what 107 is for, my lords. If you want to freeze it, get the order of the learned magistrate. He will look into it because, my lords, when we file that application before the magistrate, what the magistrate would consider is what is the extent of this crime? What is the amount that has to be frozen? Now, for an amount of 100, a freezing of 10,000 does not take place, my lords. That is the object of 107. You explain to the magistrate what you think to be proceeds of crime, why this has to be frozen. That's the object behind 107.
This is not,
Otherwise, 107 would not have come in at all.
this is not just a proceeds of crime. We also want to prevent crime. We
That-
don't want people to keep depositing the money knowing well that very
I don't
fact-
think 107 is meant like that.
No, not
For
107,
prevention,
106
my lords,
106
for
is meant for
prevention, you can't say I'm going to debit freeze anyone's account. No,
106 is meant
that
for
is never
Entire-
meant for that.
Entire
So,
scheme is-
prevention is better than cure.
Okay,
ಇದ್ರಲ್ಲಿ
on what basis prevention? So in my respectful submission, my lords, on that score
We'll see,
itself,
this will have to answer.
all the, my lords, the third one, an added aspect is immovable property ceiling, which I've given 2019 on a
That
reference.
we'll see.
It is not allowed at all, my lords, not possible.
No, it is there, immovable as a property.
Well, and also,
Seizing the
if
office,
so
madam.
required, my lords, I will point out the observations of the trial court never intended, even under the
That's-
stretch,
that-
my lords.
That I will look at.
Yes, my lords, what was pointed out there is, my lords, the police has not been able to produce anything to show that this is proceeds of crime is how the court proceeds, not on the basis of my lord's order. That
The
confusion is
court
not
has
on my
gone on,
lord's
the
order.
court has gone on 107.
Yes, the trial court did not go on 107, my lords, probably
Then
that
it could not have decided it is proceeds of crime. If it is proceeds of crime and that should be attached, it's only 107.
107,
Well, it's only debit freezing.
debit freeze, yes, my lords. All these judgments I'm giving is on debit freeze. Because the IO doesn't have that power without the order of the magistrate.
Whether I can go whole hog against all this.
No,
No?
probably,
No, but I-
I'm sorry, my lords. I'm sorry.
No, but-
Otherwise, we'll be setting it all.
No, but as your lordship pointed out, my lord, it's a very important issue now. The cyber tip line which exists virtually has to be stopped. The banks
Cyber, Malabar Gold may be noticed. Cyber crime.
virtually it has to be stopped and we have to allow all this. After that, we'll go to Jamtara and then probably look for these people who withdraw their cash from the
My
bank.
lords, at page 116, Malabar Gold, my lords. Page 116, paragraph
No.
18,
Uh,
Malabar Gold Ali.
Sanjay sir, what you're saying may be correct. I'm not on that. But the court's concern is about the victim's rights.
That's the
See,
reason.
somebody loses 50 lakhs and that gets vanished. Today, everybody is falling prey to cyber crime. How will the police protect it? If immediate action is not taken, ಈಗ FIR register ಆಗ್ಬೇಕು, ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು, ಬರ್ಬೇಕು, you know the rush there, or whatever it is, circumstances may be manifold where you can't get it immediately, and by then gone. That's what, because at the click of a button, everything goes
Okay, my
today.
lords, I will not trouble my lords on that illustration because here
No,
straight away,
you may not trouble, it's a case.
in this case,
But
my lords,
it's a
because here
case,
is a
but we will
case.
be laying down a law.
My lords, but here it is a case where FIR is registered. During the course of investigation, this has been done. That is impermissible. Would be
Correct. If
I
that
will not
now
go on the
now
illustration.
interpretation on 106 saying debit freezing also will require a permission of magistrate, that may create a
That
problem.
is what is there
may create a
consistently.
problem
My lords,
with prima facie.
consistently, if it is an FIR that is registered, in the course of investigation, you want to debit freeze 107, you have to follow. This would be my, not on the illustration that my lords had, my lords, what if there's no FIR? But this is not a case of that nature at all. You're in the course of investigation. You
Because
wanted to debit freeze. Should you follow 107 or not?
So every perpetrator of crime sitting at the click of the mouse takes away everything. And how do you protect?
ಇದು ಅಂತದಲ್ಲ my lords.
ಅಲ್ಲ, ಇದಲ್ಲ.
ಇದಲ್ಲ, because we
debit
will-
freezing is 107 ತಂದು ಬಿಟ್ರೆ problem.
But that is exactly what consistently, my lords.
That's what I'm thinking.
No, even
And my lords,
Caesar
please
of
notice
Caesar
how
of-
No,
long.
we'll have to see. It's
My
not
lords,
only the
during
right of the
Alla,
accused, victim
Kelly,
also should be.
during the course of investigation, my lords, what is the IO doing? He is writing a letter to the bank, debit freeze. Now, what does the law mandate? You give your application to the magistrate. And if the magistrate feels ex parte, it
No,
is
ಮುಂಚೆ
required to be
ಯಾಕೆ
done.
ಮುಂಚೆ ಯಾಕೆ ಹೇಳಿದ್ರು ಅಂದ್ರೆ, now because if a debit freeze is required immediately, it should be done and immediately reported to the magistrate.
To be done is writing a letter to the bank. All that the law mandates is you file your application before magistrate. That's all is a change. My lords, and magistrate has been given the power of an ex parte order.
Let me see.
If he's given the power of an ex parte order in a circumstance as seen in the illustration, my lords, he would pass an order right away and give us opportunity after that. Otherwise, it's a case of giving us opportunity, hearing us, then passing an order of attachment. But because of
That's a
15
typical attachment proceeding.
attachment, but here, my lords, ex parte order, you point out to the court, this is the proceeds of crime, we need to freeze it. Court will pass an ex parte order.
No, that is proceeds of crime, sir. In this case, proceeds of crime.
Iddu kuda
But on a
Alla,
cyber crime, losing money
now
on,
here also
see,
proceed-
online frauds happen day in and day out. So online frauds, only people, innocent people lose a lot of money. So should not the police be
lords,
given the
if-
power to protect it at least
lords,
and
if-
then report to the magistrate?
if required, my lords, I'll just give a note, my lords, how to reconcile 106 and 107. I'll
Very,
give a note.
very
on that.
important.
I'll give a note on that, my lords. I'll give a note on that on the basis of how it has been looked into. I'll pass on a note also.
Even
But otherwise, in our case, we're straightforward, my lords, FIR registered, course of investigation, this could
case
not.
fine will consider.
Please,
it.
my
All
lords.
right. But this becomes a law.
Yes, my lords.
It's become a law rather.
It's become-
Becomes any lie, yes.
no, even
And probably, my lords, even when we look at it from the other side, some check and balance which we are looking
check
at
and
also.
balance,
Because we have seen instances, my lords, not that it's always against an accused. Sometimes, my lords, even it
No,
could
I'm
be
not,
against. the-
I'm not on that. See,
Yes,
the
ma'am.
interest of the victim who would lose money online should also be protected.
I'll
Because
work
now
on
there is a portal where 1019,
1093,
109,
1093. Man.
1093, if you dial, straight away it goes to the cyber command center. Then what is the complaint? Immediately that account is frozen. Then it is reported, investigated. If there is nothing, it is defrozen. That is the procedure I think now followed. That all that would go redundant now.
No,
Because you have to report to the magistrate, I want to freeze that account because of reasons 1, 2, 3, 4. Magistrate will analyze. Then tomorrow there is a wrong analysis 482. Magistrate has not applied his mind to permit the freezing.
Anyway, my lords, I will also look at submitting a note, my lords, reconciling 106 with 107 and the illustration given by the court. What would happen in a situation like that, especially cybercrime? I'll just prepare a note on that.
No, even in instance of this case, my lord, we're talking about alluring people to deposit money for whatever purpose. We are saying that it is it is crime. We are preventing the crime by stopping the bank account. We are also preventing the crime, assuming my lord, we allow the office to be open. Entire data is in the computer and servers. If they come and take one virus, they
Alla,
can
ivrdu.
send- ivrdu. If one virus, they send it and kill it. Tomorrow, what do we investigate?
Virus.
Virus.
We've seen too many things. Anyway, my lords, in our case, this is all that is there. I will also work on a note and
All
give
right.
it, my lords. Deeply obliged. my
We'll
lords.
see.
My lords, one clarification to the bank if it is to be given, my lords, because we are not able to pay our GST even now and
No,
default
that
notices
GST I
have
have
come.
already told. What is
Lord,
this?
KPID annexure.
KPID stay ಆಗಿದೆ ಅಂತ ಹೇಳಿಲ್ವಾ ಅವರು?
That has not been communicated, my lord. You,
ಆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ? KPID stay ಆಗಿರೋದು.
Occasional KPI has
I
written
will
a
right
letter to
away
us.
give that whole setup
Lord,
because I
In
did,
fact, the statement of new accounts have been told 150 crore rupees from March.
my lords, we are-
Collected or transferred?
Collected there.
My lords, if it is coming to the aspect of accounts, I can explain the whole accounts. We are not on that. The question is your action now taken, is it legal or illegal?
It is legal.
The three actions taken, my lords, in my respectful submission would not stand the test of law. This is my respectful submission. Anything more than that, we will reply. It's only to cause prejudice, means we'll also be in a position to answer. How many accounts we have, which is a parent company, we'll be in a position to answer, but I'm not on that. I'm just on the aspect of the validity of the orders passed.
Oh, should be, of course, well, your note will be helpful, but you are appearing for the accused. So.
Anyway, I'll
No,
reconcile with the
no,
judgments and,
That's all right.
yes,
Tomorrow's no, somebody will not say, take steps from
please.
the counsel for the accused. Let's see.
In this
You
matter,
give whatever you want.
No, if it's going to be helpful, my lords, I'll
No,
prepare
this,
that
this
note,
issue has to be thrashed.
I will give it.
Otherwise, 106 becomes useless in the statute book.
We will see under what circumstances 106 still is applicable with, in relation to 107. We'll see that, my lords. I'll just work on that note.
Then we will have it on Monday. We'll dictate on Monday.
my lord, in this case, my lord,
ನೀವು ಕೊಡಿ ಸರ್,
what the KPID has
ಸ್ಟೇ
directed.
ಆಗಿದೆ ತಾನೇ ಅದು?
I'm not able to pay my GST, my lords. Two notices
I have
I've
already
received.
directed you
I
to,
will have penalty.
what bank is this?
AU, my lords.
AU, what do you mean AU?
Australian Union, small finance bank. That's
Small
it.
finance bank, my lord. This letter was written by them on 13/5.
You withdraw all this amount that is there in that bank and put it somewhere else.
No, other two
360
banks gave, my lords.
After this letter, my lord.
ಈಗ ಯಾವಾಗ
360 the
ಯಾವಾಗ
stays-
ಕೊಡ್ತೀರಾ ಅವ್ರಿಗೆ?
My lord, immediately we will permit them to operate, my lord. There is a stay, this has been communicated
For
now.
GST purposes.
We've got two
For
notices from
GST
GST now.
GST purpose.
Yes. ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ಅವರು ಬಂದು ಇವ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ AU. Yes.
DPO oblige.
Let
Monday, my lords.
Monday, we are posted at 4 PM, madam.
I think Monday, even the other matter is at 4 PM, my lords. DA
Then
matters.
it's very dictating. I'll dictate at 6:30. Don't.
Please. Oblige.
My application will be taken.
ಏನ್ ಬೇಕಾಗಿಲ್ಲ. ಇದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಒಂದು ಅದಕ್ಕೊಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್. ಎಸ್.
14.
ಮೇಡಮ್ ಒಂದ್ ನಿಮಿಷ ಮೇಡಮ್. ಸಂದೇಶ್ ಸರ್, ಜಗದೀಶ್ ಅವರೇ, ವಿಲ್ ಅಪಾಯಿಂಟ್ ಅಮೈಕಸ್. ಅಂಗದ್ನ ಮಾಡ್ತೀನಿ, ಅದು ಬರ್ಕೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ Angad Kamath is appointed as amicus to assist the court in the issue. The counsel for the petitioner shall serve complete set of papers upon, will appoint amicus. Angad ಹೇಳ್ತೀನಿ. Yes, you serve a copy on him. Yes, and all the more importantly the judgment's copy. Yes, to assess the court, list the matter on at 4 PM on Monday. Yes, copies ಕೊಟ್ಬಿಡಿ so that he'll give it. Yes.
14.
This is a forest offense case. Notes the accused. Notes are the employees of the company.
ಯಾವುದು ಸರ್?
That's 14 minutes.
ಒಂದೇ ನಿಮಿಷ. Yes, sir.
It's a forest offense case lodged against the employees of the company. Notes for having dug out certain mud from a check dam installed by the company. Notes the four issues which my lords I would. One is being a non-cognizable offense. As laid down, my lords, I don't know any number of judgments,
Yes.
including the permission of the magistrate to register as well as investigate should have been there. It's not done. Number two, my lords, the company is not even made a party or an accused. That's number two. Number three being, my lords, even if you read the complaint or the charge sheet, no overt act is attributed to anyone. In fact, even a liaison officer is being made as an accused here. And number four being the last, my lord, which I don't want to press, but it's the last one is the cognizance order also does not reflect anything.
ಅದು ಯಾವಾಗ್ಲೂ ಇರೋದು.
Other, that's, Millards, I don't want to go into that as a.
ಕಾಗ್ನಿಸೆನ್ಸ್ ಆರ್ಡರ್ ಏನು ಇರೋದೇ ಇಲ್ಲ.
Millards, the first issue being, Millards, there are judgments which we have put along with the petition
ಆಯ್ತು,
itself.
ತ್ರಿಶೂಲ್ ಗ್ರಾನೈಟ್ಸ್.
Now, Millards, my learned friend would say, there's one judgment last time which my learned friend made out.
ಅದೇ ಬೇಕಾಗಿಲ್ಲ ಪರ್ಮಿಷನ್ ಅಂತ.
Bekagilla anta. That, Millards, with great respect, I would submit.
ಯಾವ್ದು ಜಡ್ಮೆಂಟ್?
Millards, I have the copy of his court copy.
ಡಿವಿಷನ್ ಬೆಂಚ್
Millards, single coordinate bench.
ಅಂದ
Illa. Justice Sachin Magdum.
ತೊಳಿ.
Unfortunately, Millards.
Not unfortunately, fortunately.
Ayyo, it is your
ಅವ್ರು
version.
ಹೇಳ್ತಾರೆ.
It's his version. He'll get his turn. Millards,
Yes.
the right course would have been, all the judgments should have been placed before the court, coordinate bench. The coordinate bench, if it did not agree with the earlier views, ought to have referred it to a larger bench. Now, what the coordinate bench, in that case, my lords, there are two things here. Number one, the permission of the magistrate had been obtained, which your lordships would get. My lords, at running page 4 in the just above para 4. And Reliance placed on a forest manual to say, my lords, forest manual permits the range forest officer to register the crime. Now, my lords, in one of the earlier judgments which your lordships have quoted, which I have that, in 2010 itself, a coordinate bench, my lords, had held, unless the Forest Act, my lords, forest manual is only executive instructions.
ನೀವೇ ಅಪೇರ್ ಆಗಿರೋದು ಜಗದೀಶ್.
Adhan itkondo, now what they say is the earlier judgments are of no relevance. That, my lords, with great respect.
All are noticed here.
No, please see, it is not noticed. Nothing is dealt with, except saying these are the judgments. Not a single thing what the court has done, except relying on forest manual, which is a set of executive instructions. In fact, in
But the offenses are non-cognizable.
non-cognizable, admittedly
Admittedly
non-cognizable.
Admittedly non-cognizable. Rule 65 is what I have argued this matter, my lord. Rule 65 is what talks about it. Unlike FIR in regular police station, FIR kept in a police station, in a forest, FIR carried along with the forest guard. Because if offense is detected while he was on duty, he has to mention it, write it in 3 copies and send it to appropriate people. He cannot come back, say that offense has been committed and I'll register an FIR. It is not like a regular police station issue. That is what Rule 65 talks about it.
No, correct. Anyway, where is the order of cognizance?
Lords, that your lordships would get in page 54, my lords. It starts at 54, please come to 55.
ಎರಡು ಪೇಜ್ ಇದೆಯಾ?
2 page ಅಲ್ಲ, ಆರ್ಡರ್ ಶೀಟ್ ಅದು.
ಹಂಗೆ ಹೇಳಿ.
55 ಅಲ್ಲಿ.
ಆಯ್ತು, ಆ ಆನ್ಸರ್ನ ಆ ಇಶ್ಯೂನ ಆನ್ಸರ್ ಮಾಡೋಣ ಈಗ, ವಿಚ್ ಶುಡ್ ಫಾಲೋ ಅಂತ. Heard the learned senior counsel K. N. Panindra appearing for the petitioner. The order of the concerned court taking cognizance of the offence reads as follows. Page 55 marked portion. There is not even a semblance of application of mind as is necessary in law to take cognizance of the offence. The learned senior counsel has projected 2 more submissions, 2 more contentions with regard to the, three more with regard to the illegality in the entire process itself. One being the offences admittedly non-cognizable without the permission of the learned magistrate as obtaining under the CRPC, the crime is registered. CRPC with Quay 155(2), the crime is registered. The
Second one is the company is not made.
The company is not made a party to the proceedings. Third
is, my lords, reading of the complaint or the charge sheet.
would not make out in, that's okay. He would further submit that reading of the charge sheet of the complaint would not make out any ingredients of the offences that are laid against the petitioners. All these would require an answer. Predominantly an answer to whether the non-cognizable offences under the under the MMDR could be
Forest Act.
under the Forest Act could be registered without the permission of the learned magistrate. Judgments galore in favor of the petitioner, but one solitary against the petitioner. Therefore, the matter would require consideration. List this matter on 14th July.
This is confirmed by Supreme Court.
ಹೌದಾ?
SLP is dismissed. That's
ಅದೋಗ್ಲಿ.
all.
SLP dismiss limine, no.
Let's stay.
ಸ್ಟೇ ಮಾಡಲು ಮಾಡ್ಬಿಡಿ. Therefore, there shall be an interim order of stay of further proceedings qua the petitioners to the next date.
15,
7 na 13 agaro? 2nd July. Objections if, copy kudi sir.
Served it today.
The petitioner to serve set of papers upon the aforesaid council, list on 2nd July. Next.
Please, Judge.
Objections if any by the next date.
16,
Hemant.
B report filed in this case, my lord.
Huh?
Taking the B report, cognizance has been taken, that which is at page number 19. Yeah, without assigning any reasons.
Page?
19, 19. Even affidavit is also.
Offense ಏನ್ sir? 379.
379.
ಏನ್ ಕದ್ರಿ?
ಅಯ್ಯೋ ಏನು ಕದ್ದಿಲ್ಲ. ನಮ್ಮ ಅಕ್ಕನ ಗಂಡ ಇವನು, ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2.
So?
ಸೆಟ್ಲ್ಮೆಂಟ್ಗೆ ಅಂತ ಹೇಳಿ ಕೋರ್ಟಲ್ಲಿ ಮೇಂಟೆನೆನ್ಸ್ ಕೇಸ್ ಹಾಕಿರ್ತಾಳೆ ನಮ್ಮಕ್ಕ. ಮೇಂಟೆನೆನ್ಸ್ ಕೇಸಲ್ಲಿ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿದ್ದಕ್ಕೆ ಏನ್ ಮಾಡ್ತಾನೆ, ವರದಕ್ಷಿಣೆ ಕೊಟ್ಟಿದ್ದ ಗಾಡಿ ಒಂದು TVS ವಿಕ್ಟರ್ ಇರುತ್ತೆ ನಮ್ದು.
ಯಾವ್ದು? What is the order?
ಆರ್ಡರ್ ಬಿ ರಿಪೋರ್ಟ್.
Separate order ಅಂತಿದೆಯಲ್ಲ, ಎಲ್ಲಿ ಅದು?
ಅಲ್ಲ, ಪೇಜ್ ನಂಬರ್ 19 ಸ್ವಾಮಿ.
ಅದೇ cognizance for the offense is taken, separate order ಅಂತಿದೆ, ಎಲ್ಲಿ ಅದು?
ನಮಗೆ ಸೆಪರೇಟ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿಲ್ಲ.
ಇರುತ್ತೆ ನೋಡಿ.
ಅಲ್ಲ, ಫುಲ್
ಮೇಲ್ ಕಾಣ್ತಾ ಇಲ್ವಾ? Order pronounced in open court with a separate.
ಅಲ್ಲ, ಮತ್ ಪೇಜ್ ನಂಬರ್ 34 ಅಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ಪೇಜ್ ನಂಬರ್ 34 ಲಾಸ್ಟ್ ಪ್ಯಾರಾ.
ಈ report is rejected, cognizance is taken.
ಅದೇ where is the order ಅಂತಿಲ್ವಾ?
ಅಲ್ಲ
ಇವರು ಬರೀ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ, ಡೀಟೇಲ್ಡ್
Anyway, this is not a matter where B report had to be rejected. How it is rejected is a different thing. One HCGP2, one additional SPP2 emergent notice. In the meantime, there should be an interim order of stay of further proceedings before the concerned court till the next date. Next.
17,
Petitioners in this case, section 85 of BNS and 3 and 4 DP Act, your lordship, they are the in-laws. They are the
Madam, 498 format ಇದೆ ಅಂತ. SJK ಯಾರಿಗಾರ ಕೇಳಿ 490. Yes. State, next.
18,
Withdrawal.
This is the case in forgery case.
For withdrawal ಅಂತಿದೆ?
No, my lord. Withdrawal, the accused number 1 has filed the earlier case. The office has mentioned that in the crime stage, accused number 1 has filed and then.
ಈಗ charge sheet file challenge
Now,
ಮಾಡಿದ್ದೀರಾ?
charge sheet has filed. These petitioners arrived as accused number 2, my lord. Say only for impleading this petitioner, only for the statement of the witness, your honor. There is no name in the FIR. He is not making any allegation in the complaint. Nothing is there, my lord. Only the statement given by the Puneet Kumar, the page number 32, my lord. Page number 32, my lord. ದುಡ್ಡು ಕ್ಯಾಶ್ ಅಲ್ಲಿ ಕೊಟ್ಟೆ, ಅದನ್ನ ನಾನು ತಗೊಂಡೋಗಿ DD ತಗೊಂಡ್ಬಂದೆ ಅಂತ ಹೇಳಿ.
ಆಯ್ತು, ಒಂದು ನಿಮಿಷ. In the meantime, ಗೊತ್ತಲ್ಲ? Yes.
19,
Yes, sir. 306.
306, my lord, the petitioners are accused number 6 and 7, my lord. Allegation is, my lord, the accused number 1 to 4 and the deceased were the, lord, residing to in the locality.
Judge sir, 6 and 7 ಮೇಲೆ ಏನಿಲ್ಲ. The petitioners are accused number 6 and 7 in SC 286 of 2024, registered for offences punishable under section 306 read with 34 of the IPC. The role of the petitioners is not indicated in the complaint, in the charge sheet, or in any of the statements rendered. They are without any rhyme or reason drawn into the web of proceedings for offence punishable under section 306. Section 306 would require the ingredients of section 107-abetment to be present in a case of abetment to suicide. There is not even a semblance of offence against these petitioners. Therefore, permitting further proceedings would run foul of the judgment of the apex court in the case of 2025 SEC online SC page 233 to Yadvinder Singh versus Sons. There shall be an interim order of stay of further proceedings where these petitioners accused 6 and 7 till the next date of hearing.
Tomorrow is charges, my lord, may require for answer.
Huh?
Hand over.
Stay badwa?
Hand over, my lord.
Hand
Tomorrow is
delivery.
charges.
ಆಯ್ತಾಯ್ತು. and delivery. Yes, next.
20,
Petitioner having been quarrying lease for last more than 20 years. That is
ఇప్పుడేం ప్రాబ్లం అయింది?
ఏం problem Milad, the police itself Milad filed complaint without there being any
ಸುಮೋಟೋ
sumoto.
ಮಾಡ್ಬೋದ?
ಮಾಡ್ಲಿ ಬಟ್ ಅವ್ರು ಹೇಳೋದು there is no
ಎಕ್ಸ್ಪ್ಲೋಸಿವ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಸುಮೋಟೋ ಮಾಡ್ಬೋದು.
ಅಲ್ಲ ಮಾಡ್ಲಿ ಬಟ್ ಯು ಲಾಸ್ಟ್ ಮೈ ಕೈಲಿ ಏನು ಮೆಟೀರಿಯಲ್ ಇಲ್ಲ ಅಂತ ರಾತ್ರಿ ಹೋಗಿ ಅವರು ವರ್ಕರ್ಸ್ ಹತ್ರ ಏನಿರುತ್ತೆ ಪರ್ಮಿಷನ್ಸ್ ಅವೆಲ್ಲ ಐ ಗಾಟ್ ಆಲ್ ದಿ ರಿಕ್ವಿಸಿಟ್ ಪರ್ಮಿಷನ್ 20 years
ರಾತ್ರಿ ಯಾಕೆ ಹೋದ್ರಿ?
ರಾತ್ರಿ ಬ್ಲಾಸ್ಟ್ ಮಾಡ್ತಾ ಇದಕ್ಕೆ ಹೋಗಿದ್ವಿ.
ಓ ರಾತ್ರಿ ಬ್ಲಾಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ರು.
ಅಲ್ಲ ಯು ಲಾಸ್ಟ್ ಮೈ ಕೈಲಿ ಸಿ ದಿ ಕಂಪ್ಲೇಂಟ್.
The blasting is done in the night and blasting is done without having an authorized persons who required to be
Present there.
So therefore, my lord, that we have registered a case. We
ಅಲ್ಲ
found
ಅದಲ್ಲ
231 gelatins and 50
ಪ್ರೊಸೆಸಿಂಗ್ ಅಂತ ಹೇಳಿದ್ರು.
detonators.
You lost my kindly the materials obtained on 4th itself. Annexure, last annexure I have produced. Invoice I produced. M&N. 4th June evening ಬಂದಿರೋದು. Even blasting ಅವರ possession ಅಂತ ಹೇಳಿದ ಅವರಷ್ಟೇ.
Why did you blast in the night?
ಇಲ್ಲ ಬ್ಲಾಸ್ಟ್ ಮಾಡೇ ಇಲ್ಲ ಅದು.
Where is the inspection report?
I'll place it, my lord, because I've been told it was blasting has taken
Place.
You lost otherwise I cannot lift the material also.
ಏನು ಮಾಡ್ಬೇಡಿ ಇರಿ ಸ್ವಲ್ಪ.
ಅಲ್ಲ ಏನ್ ಮಾಡಲ್ಲ ಬಟ್ ಬಿಕಾಸ್ unless
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ನಿನ್ನೆ
just a date.
4th itself.
ಅಯ್ಯೋ 5626 ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದು.
You lost my kindly the complaint ಅದರಲ್ಲಿ ಯಾವುದೇ ಪರವಾನಗಿ ಪಡೆದುಕೊಳ್ಳದೆ ಅಕ್ರಮವಾಗಿ ಅಂತ ಹೇಳಿದ.
Inspection report.
Annexure K and L you lost.
Learned additional SPP is directed to accept notice, secure the report of inspection, as the allegation is that the petitioners were wanting to blast in stone either. Blast in the quarry. In the quarry during the night hours, which is prohibited, is the submission. The inspection report we placed on the next day, Tuesday, fresh matters.
ಎಂಟ್ರಿ ಮಾಡ್ರಲ್ಲ
ಅವತ್ತು ಈಗ ಅಲ್ಲಿವರೆಗೂ ಬ್ಲಾಸ್ಟ್ ಮಾಡ್ಬಿಡಿ.
ಬ್ಲಾಸ್ಟ್ ಇಲ್ಲ ಬೇರೆ ಮೆಟೀರಿಯಲ್ಸ್ ರಿಪ್ ಮಾಡೋಕು ಪ್ರಾಬ್ಲಮ್
ಏನ್ ಬೇಡ ಅಲ್ಲೇ ಇರ್ರಿ ಎಲ್ಲ
ಟಿಲ್ ಮಿಲಾಡ್
ಬರಲ್ಲ.
such time
List the matter on Tuesday, fresh matters.
21,
Please, my lord.
Review petition, my lord.
I know.
Please, my lord.
ಈಗ ಎಲ್ಲಾಗಿದ್ದು ಅಂತ ಹೇಳಿ.
My lord, the compromise petition is filed in the court and it is sent to Lok Adalat. Lord,
Not filed before the Lok Adalat.
not filed before the Lok Adalat. So therefore, my lord, my humble submission.
And the subsequent petition,
Lord,
Narendra Prasad or order ಬರ್ತಾ ಇದೆ ಮತ್ತೆ.
Lord, in the subsequent petition, what happened, my lord, pursuant to this honorable court order, they go back before the trial court, my lord, file an application for impleadment and asking for setting aside of the compromise decree. That compromise decree, my lord, without issuing notice to be, came to be allowed and the compromise decree.
That is set aside by the coordinate bench, sent it back.
Pending. My lord, the matter was.
ಅಲ್ಲ
settled
ನಾವು
before
sent it back ಅಲ್ವಾ?
Yes, my lord. Now
ಅಲ್ಲೇ
the matter
ಮಾಡಿ
is-
ಅಲ್ಲ.
Lord, the matter was settled before the Lok Adalat.
ಯಾವಾಗ?
The original compromise decree, my lord. In fact, in the writ petition, my lords may take the writ petition for a moment.
Sorry, my lord, may come to page 42 of the writ petition.
ಈಗ ಅಲ್ಲಿ ನಡೀತಾ ಇದೆ ಅಲ್ವಾ? ಅಲ್ಲ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಸಿವಿಲ್ ಸೂಟ್ ನಡೀತಾ ಇದೆ ಅಲ್ವಾ?
15:6, my lord.
ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲೇ.
My lord, I have submissions to make. My lord, when the matter is settled before the Lok Adalat and the parties have asked the court to refer the matter to Lok Adalat, and the court refers the matter to Lok Adalat and the parties have appeared before the Lok Adalat and have made the signatures, my lord, it's covered by my lord's order.
Lord,
In case of
absolutely
Guramma.
It's covered by Hakubai's judgment, my lord, where the court cannot.
Impose, going before the Lok
Lords may
Adalat.
take
It's recorded by the court. Para 11, my lord.
I think suit ನಡೀತಾ ಇದೆಯಲ್ಲ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ ಎಲ್ಲ.
My lord, in page 42, my lord.
It's a review petition ಅಲ್ವಾ?
My lord, in page 42, I have submissions.
No, subsequent
My lord, both
order
the
is
parties
passed
have
by.
appeared.
Subsequent order is passed by. You have appeared on that day.
My lord, I have not appeared. My very
ಯಾರು
contention.
ನಾನ್ ಮಾಡ್ಬೇಕಾರ?
My lord, my very contention
No,
was
no,
notice
before
was-
me you did not appear?
I appeared.
Then, yes.
My lord, I have submissions to make. Lords may grant me 2 minutes.
No, to ಹೇಳಿ.
Take me on Monday, my lord.
No, 2 minutes ಅಂತ ಮಂಡೇ ಅಂದ್ರೆ?
I have submissions to make, my lord. I have produced the copies in the
It's a
writ petition.
review, sir. You
Please, my
challenge
lord.
it.
My lord, this is a jurisdictional error, my lord. When the matter is referred before the Lok Adalat, my lord, the trial court does not have jurisdiction to entertain an application under order
ಈಗ
23
separate
rule 3A.
ಇನ್ನೊಂದು ಹಾಕಿ ಅದು ಇನ್ನೊಂದು ಪ್ರೊಸೀಡಿಂಗ್ ಆಗಿ
ನಾನ್ ಹಾಕಿಲ್ಲ.
ಅಲ್ಲ I cannot put the clock back now.
My lord, Nan Akila, my lord, the
Challenge it,
very respondent herein filed a writ petition before this court. He came before this court, my lord.
Correct, sir, you are also present.
Lord, I was present, my lord. This
Matte?
aspect was not brought into
No,
notice,
no,
my lord. There's a
yes.
jurisdictional error on this point.
The
My lords, I have,
the
my lord,
petitioner,
grant me 2 minutes, my lord. I'll make my submissions.
Monday ಅನ್ಬೇಡಿ ಈಗಲೇ ಹೇಳಿ.
Tuesday or Monday or
ಮತ್ತೆ
Tuesday.
ಈಗ 2 minutes ಅಂದ್ರೆ
I'll
ಈಗಲೇ.
get the writ petition copy. In the writ petition copy, my lord, both the parties have signed before the Lok Adalat. My lord's judgment says when even a third party to a Lok Adalat award cannot file an application, my lord, before the same court, the only avenue is left to him is to file an Article
That
226
is if
petition.
you are not a party.
Even if you're not a party, my lord, he is not a party. He is not, it's signed. My lords may take page 42, my lord, of the writ petition. I have it here. My lord, in the writ
No,
petition.
you are re-hearing matter, sir.
My lord, I'm not, my lord, I'm on the single point, my lord, the
And
jurisdictional error.
subsequently, impleading application is filed, that is again sent back.
My lord,
ಇದು
with respect to that,
set
let me
aside
make
ಮಾಡಿ ವಾಪಸ್
submission. My lord, with
ಕಳಿಸಿದಾರಲ್ಲ.
respect to that, let me make submission. My lord, after my lords pass this order, they file an application before the trial court seeking for impleadment and setting aside of this compromise decree. They don't serve me any notice.
That is on that is set aside now, sent back, right?
Sent back, my lord. My lord, this review petition is on the point that matter is referred before the Lok Adalat and both the parties have made the signatures.
ಈಗ
My
ಎಲ್ಲಿ
lords,
ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಡೀತಾ ಇದೆ ಈಗ?
in the same court, my lord, senior civil judge and JMFC Devnalli.
Devnalli, my lord, the civil judge, senior.
ಆಯ್ತು ಈಗ
But it's covered by-
one ನಿಮಿಷ.
please.
Now we have sent it back to the same court.
Please.
Not a problem. Now admittedly they were not parties,
Please, ma'am.
correct, to the compromise.
Please, they were not parties.
ಹೌದಾ? They were not parties. Even if I recall this, I will take it up in the writ as a writ petition, quash it and send it back to the same.
It can't be sent back. It's the entire compromise has to be.
The compromise will go. Compromise will go and I will send it back.
My lord, that may be done by my lords in the writ petition jurisdiction. That may be done, my lord. It may be, papers may be called back. I have documents to show, my lord, this respondent executes a release deed in my favor, accepting a sum of rupees 31 lakhs. And now, my lord, after a period of 2007 was the compromise.
Correct.
And now they come, my lord,
The compromise is not a party ಅಲ್ಲ.
compromise. Please, my lord, they were not a party.
Yes.
They come after a period of 15 years and file this petition.
Not a compromise, not a
Lord,
party,
I
it's
have,
over.
my lords may take that in writ petition, my lord, I'll make my submissions. In the writ petition, my lords may entertain that, my lord, not in the original suit.
Now there is subsequent development, sir. What
Lord,
is
in
all
subsequent
this?
suit, it was not a party.
ಇದು ಈ ಕೇಸ್ ಆದ್ಮೇಲೆ ರಿವ್ಯೂ ಹಾಕಿದ್ದೀರಾ ಈಗ?
No, my lord, the review was filed before. My lord, review, my lords may
Just
take.
because that
20 to
application
9
was entertained, no, sir.
My lord, 20 to 9 only I've made my review. My lords may call for writ petition papers,
No,
my
no,
lords.
Now, because of the subsequent order, we will not entertain.
My lord, subsequent orders was the very ground it was quashed on the ground that notice was not issued to me.
All right, that is now pending before the court.
My lords may take, my lords may take this, my lord, writ petition papers may be called for and the matters may be kept on Monday, my lord, I'll make my submissions. Writ petition papers may be called for.
Coordinate bench of this honorable court has passed an order, my lord, the procedure, how the.
Correct. Idrale, this is what I have followed and said. You can't force a person to go to Lok Adalat.
We are not forced, my lord. Parties have asked
no,
the
no.
matter to be referred to Lok Adalat. This there in writ petition order sheet filed by my learned friend. Page 42, my lord, writ petition was filed by my learned friend before this court asking for setting aside of the 2007 compromise decree. In that, my lord, compromise petition.
No problem. That compromise I will myself quash.
My
If you
lords
want
may
me to
call for
quash it, see if I have sent it back. You say there is error. I will recall this order. I will quash it myself. Following
My
this,
lords may recall this
following
order.
this judgment, I will quash it and send it back.
My lords may recall this order. My
So
lord.
you want the compromise decree to be quashed here,
My lords,
or you want to contest it there? You tell me.
My lord, I don't want
I
the
will
compromise
definitely
decree
quash
to be
it here.
quashed.
Yes, I will.
I
quash it.
have points to make on merits, my lord. They execute a release deed. That is on another point, my lord. Now, my lords may call back the writ petition papers.
You contest everything, sir. There.
My lord, it would be a jurisdictional error. My lord, the recent judgment of Honorable Apex Court in Dilip Mehta clearly states, my lord, even if he is a party or not a party, the only avenue
That's
to
what I
challenge.
have also written.
Please, my lord. Please, my lord. Gurama judgment. I have got my lord's
that's
order also. Lord, my lords should entertain jurisdiction under Article 227, my lord, not to be sent back. This is a jurisdictional point on this. I have the order sheet of the original case, my lord, where the parties requested the matter to be referred to
tell
Lok
me
Adalat.
now, after this, there is subsequent proceedings, subsequent orders passed by the coordinate bench. You have acquised yourself
I
there.
have not acquished.
Allah, now you have gone back
ಅವ್ರು
there.
ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಅವರು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ವಿತೌಟ್ ಇಶ್ಯೂಯಿಂಗ್ ಮೀ ನೋಟಿಸ್.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಯಾಕೆ ಮಾಡ್ಲಿಲ್ಲ ಅಲ್ಲಿ? ಅಲ್ಲಿ ಅವ್ರನ್ನ ಹೇರ್ ಮಾಡಕ್ಕೆ ಏನಾಗಿತ್ತು ಕೋರ್ಟ್?
ಜಸ್ಟಿಸ್ ನರೇಂದ್ರ ಪ್ರಸಾದ್'s ಆರ್ಡರ್ ಮೇಲೆ for the moment.
ಎಲ್ಲಿ? ಈಗ ನರೇಂದ್ರ ಪ್ರಸಾದ್ ಅವರ ಆರ್ಡರ್ ಮುಂಚೆ.
ಪ್ಲೀಸ್
ಅದು ಅವ್ರು ಫೈಲ್ ಮಾಡಿರೋದು.
ಅಲ್ಲಪ್ಪ, ಅಲ್ಲಿ ಆ ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅವ್ರನ್ನ ಹಿಯರ್ ಮಾಡ್ಲಿಲ್ವಾ?
ಇಲ್ಲ, ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ಆ ಅರ್ಜೆನ್ಸಿ ಯಾಕೆ?
In fact, my lord, the matter was advanced and the notice was not issued to me. On the very ground, my lord, the matter was recalled and the matter is sent back to trial court. My lords may call for writ petition papers and decide it here, my lord.
Lord, they were made parties. They had come to this court saying that they were not made parties there. They were not heard.
That is just Narendra Prasad ಅವರು.
Please, they were made parties there.
they were made parties, but ಅವ್ರನ್ನ ಹಿಯರ್ ಮಾಡದೆ ಯಾಕೆ ಅರ್ಜೆನ್ಸಿ ಇತ್ತು ಅಂತ ಹೇಳಿದ ಅಷ್ಟೇ. We'll see, we'll pass orders tomorrow. ನಾಳೆ fresh matters ಹಾಕಿ ಮೇಡಮ್.
Lord,
subsequent proceedings, sir. ಅದಕ್ಕೆ
tomorrow is one difficulty, my lord. Tuesday or Monday, my lord, one exam.
ಆಯ್ತು, Tuesday exam.
Some master's exam. So
Masters?
Tuesday.
All right.
Tuesday.
My lord, there is a procedure laid down by this on coordinate bench, my lord, how the file has to be sent to the Lok Adalat, my lord.
That is admittedly not followed, not a problem.
Otherwise case, my lord, it says, my lord, the Lok Adalat, there should be a separate order sheet. And the proceedings are.
That is not even there here.
It's not even there. Compromise recorded before the court.
No, let me see. I will answer his review petition.
Please. 17.
Tuesday.
17.
Wednesday, fresh
Please.
matters.
Grateful. Great. I shall bring the order sheet of the original.
Yes, yes. Avat will close it that day.
Please.
But difficult subsequent proceedings.
My lord, if the matter, I'll make my submissions.
I am aware, sir. Jurisdictional error would cut at the root of the matter.
Both the parties.
Rudimentary things you need not tell, but.
Both the parties have asked for the matter to be referred. Lok Adalat ellaru signature hakidare. So it's not like matter was settled in Lok Adalat and compromise petition was filed in civil court.
Yes, we'll see.
Entirely different before the Lok Adalat and the court, my lord.
We'll see. Yes.
Supervised judgment, my lord, says the court, it cannot be a Lok Adalat.
Right. We'll see that. Follow whatever to be written. We'll write on Wednesday.
Please.
All the best for your exams.
22.
Travel itinerary I'm filing. Passport. Paragraph number 5 and 6.
Shanta Bhushan, sir. Nodidra?
Only thing is that, my lord, no document is produced. Otherwise.
A document ಕೇಳಿದ್ನಲ್ಲ ನಾನು.
Our passport illa.
Passport?
Passport expire agogide. So when a passport is expired, they cannot get the travel ticket also.
I have to get the visa, then my lords, then I have to travel.
ಮತ್ತೆ ಟಿಕೆಟ್ ಹೆಂಗ್ ಸುಮ್ಮನೆ ಇದು ಡಮ್ಮಿ ಟಿಕೆಟ್ ಕೊಟ್ಟಿರೋದು?
ಇಲ್ಲ ಟಿಕೆಟ್
ಇಲ್ಲ passport ಇಲ್ಲ ticket.
The petitioner is before the court calling in question the proceedings in CC 459 of 2024 registered for offences punishable under section 279 304A of the IPC. The issue in the list is not with regard to the merit of the matter. The petitioner is wanting to travel beyond the shores of this nation owing to his avocation. The passport that is now expired is refusing to be renewed on the score of the pendency of the proceedings, pendency of the subject proceedings. In that light, the petitioner has placed on record his travel itinerary, the date of travel and date of entry back into the shores of the nation. The affidavit reads as follows.
Paragraph 5 and 6.
Affidavit ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್. Though no document, ನಾನು ಏನ್ ಕೇಳಿದೆ ನಿಮ್ಗೆ? ಏನ್ ಟ್ರಾವೆಲ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಿ?
For upskilling, my lords, in the IA I have filed, my lords. That
ಎಲ್ಲಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ? ಹಾಕಿದೀರಾ?
Documents,
ಮತ್ತೆ?
There is no document, my lord.
All right, sir. Allah, you want to go to some program or what?
Upskilling, my lords, program of the company.
Upskilling. All right, sir. What skill you have?
I'm an engineer.
Oh, you want to upskill that? Yes. The affidavit reads as follows. In the light of the petitioner wanting to travel and the passport having been expired, I deem it appropriate to direct the passport authorities to issue a short again SVP issue the passport in accordance with law, and pursuant the petitioner shall abide by the undertaking in the affidavit. In the event the petitioner would not cooperate with the trial by not coming back to the shores of the nation, it is open to the passport authorities to take necessary steps to impound the passport of the petitioner. Passport in accordance with law. Yes. ವಾಪಸ್ ಬರ್ಬೇಕಲ್ಲ
ಬರ್ತೀವಿ
ಅಪ್ಸ್ಕಿಲ್ ಆಯ್ತು ಅಂತ ಅಲ್ಲೇ ಇದ್ಬಿಟ್ರೆ
ಬರ್ತೀವಿ.
because you killed someone, rash and negligent driving.
Allegation.
Now you can't escape trial. Yes.
We will face the trial.
Great. Only IA is allowed. Yes. Petition list after 2 weeks. Yes.
Interim order earlier granted maybe.
Interim order subsisting would continue to the next date of hearing.
23.
Petitioner Malaysia, Praxi Council, 1 week press parliament.
Expedited trial.
I'm asking for expedited trial, my lords. I'm the petitioner.
You have filed a
23
petition?
For the petition on 23. Criminal petition connected.
Innondu yavadu?
It's connected with their 482, my lords, which they've sought for quashment of the order of cognizance. There's no stay in the matter.
ಯಾವ ವರ್ಷದ ಸ್ಟೇ ಇಲ್ಲ ಅಂದ್ರೆ ನಡೀತಾ ಇದೆ ಮತ್ತೆ ಯಾಕೆ
ಇಲ್ಲ ಅವ್ರದ್ದು it's just exempted from personal presence till next date and it's constantly extended.
2024 da ಏನು urgency?
Swami, the FIR is 2015. They got a stay in the crime stage. They suppressed the fact that petition was dismissed by this honorable court in 8057 by 2015. Wide order dated 22nd December 2022. Subsequently, my lords, there's a direction for FSL to be conducted. It's a case of forgery. That FSL report takes some time and thereafter the IO himself takes 2 years to file the charge sheet. 2024, the charge sheet is laid before the honorable trial court. Order of cognizance is passed. Immediately they approach this honorable court seeking quashment, my lords.
Anything else, sir?
Malaysia, Praxi Council date.
No. Yes. The petitioners, both these petitions arise out of a solitary cause of action. One, registration of a crime by the second respondent, by the complainant, who is the petitioner in WP 29212 of 2025.
It's a legal representative of the de facto complainant. The de facto complainant has expired.
By the petition, by the complainant, a complainant, but a de facto legal representative of the de facto complainant. The issue dates back to registration of a crime in crime number 211 of 2015 for offenses punishable under 467, 468, 465, 420, 120B and 504 of the IPC. The moment the crime got registered, the petitioners were before this, the accused were before this court and the coordinate bench had granted an interim order of stay. The said stay gets obliterated on the score that on the score of the petition being dismissed in terms of an order of the coordinate bench on 12th December 2022. After which the investigation went on and the investigating officer files his charge sheet in the year 2024. The concerned court registers CCN.
CC 3942 bar 2024.
Registers CC 3942 bar 2024. The moment charge sheet is filed, again the petitioners are back at the doors of this court. However, the twist is that there is no interim order of stay in the case at hand. The legal representative of the complainant has preferred the companion petition seeking expeditious conclusion of the trial as the issue is of the year 2015. In the light of no interim order subsisting in the case at hand and the entire facts, the coordinate bench, while rejecting the petition of the petitioner of these accused, has observed as follows, page 29 to the coordinate bench clearly holds that it is an issue for investigation in the least or the petitioners to come out clean. After the filing of the charge sheet, the petitioners are again before the court. The proceedings must be taken to its logical conclusion as there is no warrant of grant of an interim order in the case at hand, particularly in the light of the finding rendered by the coordinate bench as 7 years the matter was languishing before this court on an interim order being granted in the year 2015 at the crime stage. In that light, I deem it appropriate to dispose these petitions with a direction to the concerned court to conclude the proceedings as expeditiously as possible, at any rate within 6 months from the date of receipt of the copy of the order, as the issue revolves around forgery or other forgery of a general power of attorney or otherwise. all contentions shall remain open to be considered by to be urged and considered, to be urged before the concerned court. It is needless to observe that the concerned court would consider all the submissions and answer them at the appropriate time. Ordered according. Yes, next.
Fine.
ಯಾವ್ದ್ರಲ್ಲಿ ಮೇಡಮ್?
I filed the NOC, my lord.
ಎರಡಕ್ಕೂ ಹಾಕಿದ್ದೀರಾ?
ಎರಡಕ್ಕೂ ಹಾಕಿದ್ದೀನಿ.
So and so. Memo for retirement allowed ಅಂತ separate order sheet ma'am. Yes, next.
24.
May I please. Invocation of the.
Coca.
provisions, the Coca.
Yes.
That's the, my lord, friend can, we, before the trial court, my lord, these orders of prior approval for registering FIR and further sanction orders, nothing is produced, my lords. Only a letter is given, my lord, requisition that there has been approval. And we not have the copies, my lords. I only pray, my lords, that and also request my learned friend, my lords, that if copy be furnished to us so that we are
Which
able
copy?
to, copy of the approval that is prior approval that has been granted, my lords. So that, my lords, what has been stated in the order of the learned judge in Udupi is, my lord, that a requisition is made, I am transferring the case. And that copy is not made available at all. Now, unless, my lord, the copy is made available, we will be crippled in making our defense or making our proper grounds.
Approval.
It is part of the charge sheet.
Charge sheet.
The friend gets the copy, both approval and sanction, both are there. This is,
That should would have been filed afterwards, after the filing of the petition. That's also.
both approval and sanction, both are there.
The Honorable Court permits me to get a copy from my learned friend, my lord. Copy not furnished.
Charge sheet ಅಲ್ಲಿ ಇದೆಯಲ್ಲ?
ಇಲ್ಲ, ಬಂದಿಲ್ಲ, charge sheet. When is it filed, sir?
Charge sheet is filed. I have 6 volumes of charge sheet.
ಇದೆ.
Charge sheet, if it's filed, my lords, will secure, my lords, instructing counsel
ಇಲ್ಲ,
has not
ಇದೆ.
furnished the charge sheet. I will also,
ಅಲ್ಲೇ contest ಮಾಡಿ ಅಲ್ಲ.
no, I will study the charge sheet and then make the submission.
Study the charge sheet.
Please, because I do not know, that has not been furnished. It was at the stage of.
Whole contention they are urging, my lord, that one of the case, only one case, another case have been acquitted. That matter, my lord, is squarely covered by.
That your lordship also observed on the first day itself, my lords, of the facilitator also, my lords.
Yes,
Now the
ಕೊಡಿ.
question is, my lord, whether the provision of law, COCA, is applicable or not.
Para 38, my lord, at page 423, which they extract the Bombay High Court judgment which dealt with the MOCA constitutionality, my lord. More particularly at page 425.
ಈಗ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀವಿ ಇಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ,
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 ಇಲ್ಲ, stay ಇಲ್ಲ. I will obtain the charge sheet copies, my lords.
ಏನಿದೆ?
That's what I have to
Nothing
also
that-
see.
ಆ charge
Further
sheet
materials,
ಅಲ್ಲ.
now that it's.
ಇಲ್ಲಿ
stated,
ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಏನಿದೆ?
The charge sheet materials, my learned friend said,
Charge
the
sheet
prior
material,
approval and
Kokali
the sanction order is there in
Is
the.
here.
The problems I don't have it.
Sanction order is here. Requisition is here.
Please, my lord, I don't have it. now,
Everything
right now.
is there. No ground.
It's with the, I do not know anything because charge sheet materials, my lords.
Kokali,
charge sheet
where
itself-
is the question of interference? Except that the order and things should be there, it is there.
Please, that's what I have to see the, only the order, my lords. I will,
No problem. When do you want?
any day in the next week, please, my lords.
At the request of the learned senior counsel, PP Hegde, list the matter on 25th, 24th in the fresh matters list. Pendency of this petition will not come in the way of further proceedings before the concerned court.
Please, my lords.
25.
Some led by AG, he's on his legs before Court Hall 11. Lords may have it at 2:30 this matter.
Lordship, this was only one short point.
2:30 10 ನಿಮಿಷ ಇದೆ ಅಷ್ಟೇ. 2:30 ಬರ್ಬೇಕು.
Yes,
Yes.
he's on his legs.
2:30 pass over.
26.
On petitioner, my lord. Lord, today all the petitions are listed. I have one submission to make, my lord, is that, I know the petitioners are discussing with the association on
What
completing the project.
association?
The Apartment Owners Association, the project is not completed, my lord. There is still 30-40% of the work is pending. And as per the order of the RERA, the project has been handed over to the association. And association, till now, have not. brought
Association
any-
is the complainant, is it?
Yes, madam. Different members of the association are part of the complaint.
Hmm.
So now the landlord and the petitioner, they are discussing with the association members to complete the project. They are going to pump in the money, and there are some unsold units are there that they will sell it and close it off. That discussions are going on. Maybe this matter may be taken it after 2 weeks.
I'll make my learned friend's submission is, you sort out your issues on your own. I've taken 44 crore, 80 lots.
Who has taken 44
He
crores?
has taken 44
No,
crores.
accused number 1, my lord. I am accused number 2.
Whatever.
Both are promoters.
Yes.
87% of the consideration is discharged. Only 44% of the apartment is complete.
Hmm.
Before RERA, they have not come before the court. They have not made any attempt to say that we will complete the project. They're just waiting for the honorable authority to do a takeover the project. We have taken over because we had no other circumstance, because they've literally abandoned the proceedings. Let them deposit the money. We have no intention that they
Now,
should go
the
sit-
construction is given to you, is it?
Please, Lord.
Yes, my lord.
Where is the money to complete the construction?
No, we will put in the money. Landlord and the petitioner, because there are still 29 unsold units are there, my lord. So that is based on the instructions I am making the submission, my lord. I do not know whether.
No,
the
if you are
learned
sitting
friend-
and settling the issue, I have no problem.
This is the point. If they're willing to whatever money is diverted, that's why the amount, the FIR has been lodged. 44 crores has been diverted. There's no accounts for that. If they can deposit that money in the account, and then that shouldn't be a matter. They can't say the remaining property we will sell and then raise funds. What happens to the
No,
existing money
initial
that they
funds
will-
have to be, put out of our pocket.
Let him
only,
give
my
a
lord.
proposal
The
before
land-
your lords that he will deposit the money. We have no objection to any other.
Idu PMLA yake?
Yes, my lord,
Please.
my provisional attachment order is stayed because the.
What have you attached now?
My lord, sir,
My properties, my lord.
his properties I have attached, my
Oh,
lord.
personal property.
There is a stay in all the matters, my lord. Despite
In
there is a
this,
stay.
all
Yes, my
matters.
lord. Yes, my
Because
lord.
I have filed prosecution complaint.
The best submission you make is that, wait, yes.
Despite there is a stay in they pick up one of the FIRs and they initiated this proceedings, my lord. Within 2-3 days, they went and attached the properties. First, I filed a petition for seeking stay of the notice. Notice was stayed. Thereafter, by the time the order was communicated, they attached the properties also, my lord. Even that is also stayed by this honorable court. So we are trying to resolve the issue because the original promoter is now absconding. He is not available. Against him also, I am fighting a case. There is arbitration. There is a criminal case which is going on. But to resolve this issue, so myself and the landlord have come together and we want to complete this project because till now they have not got any
But
builder.
complete this project, Adela, it's not the scope of this petition.
Yes, my lord.
But if you really want to settle it with the association who is the
Yes, ma'am.
complainant, I have no problem. Later on, we will take care of the
We have no problem if they can
enforcement
deposit that money. That's all we are
Allah,
concerned.
that is whatever you want to,
Let them
terms and settlements you draw and you inform to this court.
If they're seriously about their proposals, I don't have any objection to that.
No, let them give a proposal. What is that?
Let them give.
No, the petitioner is discussing with the association members.
Sure.
And I am here. Your
There is
Lords.
only
Even
one
the
person, my lord. There are different
President is here,
people.
Lords. President is before the court.
We will discuss and give the proposal, my lord. That's not issue.
So many cases, home buyers have been.
I am not a original promoter, my lord. That I have a
home
different
buyers
case
who
for
have
that.
hoodwinked.
My lord, I have a different case. I am the investor. I am not a original promoter. Original promoter is accused number 1. Who has been? I have not even signed a single document with any of these
Sorry,
association
that's
members.
not correct. Promoter is the promoter, is an officer of the company.
I was only
Fact,
director
you-
because I have invested the money. Because I
Yeah, crime squash ಆಗಿದೆಯಾ ಯಾವ್ದಾರು ಬೇರೆ?
there is one matter which got
Justice
settled.
ಹೇಮಂತ್ ಅವರನ್ನು ಅಲೋ ಮಾಡಿದ್ದಾರೆ ಯಾವ್ದು?
Yes, my lord.
Lords,
There is
that is, I think, with respect to another purchaser and the promoters, not with respect to the association. Association only this, Lords. 44
We'll
crores
give you a week's time. If you don't, we will.
2 weeks, my lord, at least because the discussions are going on. So that's the reason.
Going on.
I've not heard any discussion, Lords, but I'll just take it to what my learned friend today says. I'll start from today. Lords should
All
forgive
right,
your
we'll
time.
take it on 1st July.
Much obliged.
In the event no compromise, then I'll pass orders on its merit.
Much obliged.
All right?
Grateful.
Yes. The parties to the learned counsel for the petitioner submits talks of settlement are on between the complainant and the petitioners with regard to the execution of the project. The talks of compromise, if culminates into a settlement, the same be placed before the court on the next day, i.e. July the 1st, 2026. In the event there is no settlement, it is made clear that the petition will be answered on its merit on the same day.
Yes, my lord.
Grateful. Grateful.
Now tell me,
Interim
ma'am.
orders may be continued. my lord.
Yes,
I have
prosecution complaint you have filed.
And also, my lords, because we were about to issue show cause notice.
By then stay is granted.
In the FIR, the
We'll
stage
see.
is there from 2023, my lord. Even the charge sheet also, both have been.
Anyway, you have taken 44 crores from whom?
No, I have not
From
taken.
whom?
From the total, the investment which is made by all the
All
buyers
the
of
home
the
buyers.
Home buyers, my lord.
Home buyers is 44 crores, huh?
Maybe, yes, my lord.
It can't be maybe a lot.
Allah.
I was not handling the
That's
data.
all right. I'm only asking facts. If a home buyers in the, you have taken allegedly taken 44 crores and not completed the project. How many?
7% of the amount is dispersed from the banks. 40%.
The loan.
Please, 40% is
Oh,
what
subvention scheme agita.
40% is what is completed as per the RERA update.
Which builder is this?
Mangalya Construction.
Mangalya Constructions.
Mangalya Ventures. Change madbekayitu. Mangalya Adventures. Yes. All right.
Yes, my lord.
Yes.
Interim orders ಬೇಕಾ?
Interim order ಇದೆಯಾ?
ಎಲ್ಲದರಲ್ಲೂ ಇದೆ ಸರ್.
ಎಲ್ಲದರಲ್ಲೂ ಇದೆಯಾ? 44 ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ ಆಚೆಗೆ. Yes. Interim order stands extended to the next date of hearing. First ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವತ್ತು I'm going to decide.
Yes.
27.
My lords, in this matter, my lords have.
Prosecution complaint is filed.
Yes, my lords. They have challenged the proceedings.
Lords, remember
My
6
lord.
kg of gold. Lords, that was 6 kg of
ಅದೇ
gold.
ಗೊತ್ತಾಯ್ತು.
Had asked me a pertinent question with respect to the amount which was deposited. My lords, there are
That
two.
is ಅದೇ 3 ಇದರಲ್ಲಿ. ಓ ಅದು ಡಾಲರ್ಸ್ ಅದು ಬೇರೆ.
Yes.
That is yesterday.
My
Lords,
lords.
Israeli, my lords, 6 kgs of gold were caught, my lords, in Mangalore. Lords, the allegation is that, my lords, 11 lakh rupees of unaccounted cash is in the bank account, my lords, of the petitioner. That were, my lords, 6 months ago that were deposited. Now, my lords, they are saying that these amounts that are unexplained by the petitioners are, my lords, proceeds of crime. And they will now, my lords, invoke section 45 and file complaint. Lords, the only allegation is that 11 lakh rupees of amount. Now, my lords, in the prosecution complaint, they say, including the gold amount that is 1 crore 34 lakhs odd, plus 11 lakh.
We'll take it today 4 o'clock ಅಷ್ಟೇ. List the matter on 24th. IO extends to the next. Yes.
It's in the fresh material list.
28.
ಬರ್ಲಿ ಬಿಡಿ ನಿಮ್ಗೇನು.
28.
Latif.
Please. Yesterday's, day before yesterday's. The amount, there was a direction from the magistrate to release the amount, the frozen.
Axis Bank, yes sir.
My lord, in fact, I contacted my party, my lord. What they say, my lord, is that this order was passed without hearing them, but they learned match. Here's the fact, my lord, that yes, there is an order which we should have complied. The multiple freezing orders, my lord, of various authorities and the courts. Ideally, we should have filed our objections before.
You
the
should have
learned match.
challenged that order.
Yes, we are not done so, my lord.
Now
my
you
lord,
release
I
it.
leave to
You
the-
defreeze it.
Yes, my lord, one direction within 15 days ಅಂದ್ರೆ I'll have
An
to.
order of defreezing.
ಅಲ್ಲ ಇದು ಅದು ಹೌದು ಸ್ವಾಮಿ, ಆ ತರ
ಸ್ವಲ್ಪ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡೋಣ. Not
ಬೇಡ
obeying,
ಸ್ವಾಮಿ,
not
ಇದ್ರಲ್ಲಿ
obeying
ಏನಾಗಿದೆ?
the orders of the
ಅಲ್ಲ,
court.
Officers change, ಅದು genuine.
ಅಲ್ಲ, whoever it is, Axis Bank is there, is behaving too much. Notice ಕೊಟ್ಟು ರಿಪ್ಲೈ ಮಾಡಲ್ಲ. ನಾನು ಈಗ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ.
ಇದರಲ್ಲಿ ನಮ್ಮ ಮಿಸ್ಟೇಕ್ ಇದೆ.
What do you think?
Not in all the cases.
ಯಾಕೆ ನೀವು ಕೇಳಿ?
ಹೌದು, ನಾನು
ಯಾವ್ದ್ರಲ್ಲಿ ನೋಟಿಸ್ ತಗೊಂಡ್ರೆ ರಿಪ್ಲೈ ಕೊಡಲ್ಲ?
Mysore, we have issued 20 plus notices.
Nobody replies.
ಹೌದಾ? I'll check.
Then you are beyond the axis of law, na? Huh?
That time not aware.
No, sir.
ಅಲ್ಲ ಇದರಲ್ಲಿ
ಇದ್ರಲ್ಲಿ ಈಗ ಯಾವಾಗ ನೀವು ಮಾಡ
ಟೈಮ್ ಕೊಟ್ರೆ I'll advise them to settle.
ಇಲ್ಲ, ಬರೀ ನಾನು ನಿಮ್ಗೆ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದು ಯಾಕೆ ಅಂದ್ರೆ ನೀವೇ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ. ಈಗ ನಾನು ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ಲೇಬೇಕು.
ಇಲ್ಲಂದ್ರೆ ನನಗೆ 1 month ಟೈಮ್ ಕೊಡಿ, ನಾನು
1 month
my officers to do it. Yes, my lord. In fact,
1 month ಯಾಕೆ ಬೇಕು?
at least
ನಾಳೆ 24 hours.
At least ಒಂದೊಂದು ವಾರ ಕೊಡಿ.
ಡಿಫ್ರೀಸ್ ಮಾಡಿ ಏನು ಲೆಡ್ಜರ್ ಬರಿಬೇಕಾ?
ಅಲ್ಲ, it has to be transferred. ಅದನ್ನ process
ಎಲ್ಲಿಗೆ?
The branches have no powers. They'll have to go back again to the statutory
I
authorities.
don't worry. Then leave it.
ಅಲ್ಲ, ಅದು 7 ದಿನ.
No.
7 days.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಬೇಕಾದ್ರೆ 1 month ಇಂದ 7 days ಗೆ ಬಂದ್ರ?
I'll force them. At least.
ಮಂಡೇ ಬೆಳಗ್ಗೆ 10:30 ತಗೊಂತೀನಿ. ಅಷ್ಟರಲ್ಲಿ ಎವ್ರಿಥಿಂಗ್ ಶುಡ್ ಬಿ ಡನ್. ಅದರ್ವೈಸ್ I will impose exemplary costs on this bank which is violating the law, violating the orders of the court every time. You need not tell I am live. ಗೊತ್ತಾಗಿರುತ್ತೆ. Every time 20 notices are issued by the investigating officer.
I was not aware.
Because of that, ಯಾಕೆಂದ್ರೆ 3 years charge sheet file ಮಾಡಿಲ್ಲ. 20 notices, no reply. This is not the way to cooperate with the investigating agency. If we don't cooperate with the criminal justice system, we will hold you responsible. I mean the Axis Bank. ಇದು ಮಂಡೇ ಬೆಳಗ್ಗೆ ತಗೊಂತೀನಿ ಅಷ್ಟೆಲ್ಲ ರೀಫ್ರೀಸ್ ಮಾಡಿದ್ರೆ ಓಕೆ, ಇಲ್ಲ ಅಂದ್ರೆ
ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ಟ್ಯೂಸ್ಡೇ
ಟ್ಯೂಸ್ಡೇ ಬೆಳಗ್ಗೆ. ಎಸ್, ಸೆಕೆಂಡ್ ಸಾಟರ್ಡೆ ಮಂಡೇ, ಅದಕ್ಕೆ ಟ್ಯೂಸ್ಡೇ.
29.
So I need some time in this matter next week. ma'am.
ಪ್ರಿಡಿಕೇಟೇ ಇಲ್ಲ. ಇಟ್ಸ್ ಮೈ ಆರ್ಡರ್ ಅಗೇನ್.
Next week.
We'll take it.
Please.
1st July ತಗೊಳ್ಳ?
Please.
1st July. Yes.
Interim order be extended.
Interim order will continue till the next date of hearing.
30.
Next. Vella ED.
Thus I'll be filing objections in this matter, my lord.
No, so many ED cases, ED has become so active now. Yes.
Because here the only allegation against me is that I'm a dummy director. I cannot knowingly and unknowingly be a director in a company.
You're a dummy director.
Apparently, my lords. Effectively, my lords, I was a director in this company for a period of 109 days. I took no action. There was no allegation against me in the entirety of the complaint except that I was a dummy director. If I can only point your lordships through that page, my lords. Page number 260.
Yes, madam.
Yes, my lord, there is the argument, I have.
Your accused number?
A69, my lords.
My lords, what has happened is hundreds of fintech companies are established with the help of some Chinese entities. And how they establish is they take chartered accountants, all.
You're a chartered accountant?
I'm an accounting professional. Where what I have
Accounting
done
professional, they'll with the help of them, they will create these 100 fintech companies. And then, my lords, they will do the money laundering in that process. And my lords, may kindly see a
Who will do money laundering?
that Chinese counterpart in association with these people, my lords. These hundreds of
So what's the role of
professionals.
this man?
My lords, Pratibha Singh, my lords, her allegation against her is in the prosecution.
Sorry, what's the role of this lady?
My lords, at 260, it is stated that Pratibha Singh knowingly became dummy director in the various fintech companies which were used to conduct fraudulent money laundering businesses involved in extortion and harassment of customers. Therefore, Nagraj Bogala knowingly assisted the accused entities and Chinese nationals.
How will he assist? How will accounting professional assist in money laundering?
My lords, that is what has been found in the
No,
prosecution.
how?
My lords, may kindly see 11.60. It has been narrated.
We'll continue.
I will file my objections.
File your objections.
Please,
What's the stage now?
my lords, it's or the stage of summons. Next date is on 12th of August.
Because I filed my application under.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ. Next day 12th of August ಅಲ್ಲ. I'll take it on 1st again.
Please.
Very much.
On list the matter on 1st.
Great.
Objections if any by the next date. List matter ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
51.
For the petition and the matter is settled, my lords, and the victim is also the
What's the offense?
present, like the POCSO case that we
ಅದೇ
had
ಗೊತ್ತು.
regarding the freedom.
ಮದುವೆ ಆಗಿದೆ ಅಂತ ಸೆಟ್ಲ್ ಅಂತಿರೋದು ನೀವು?
Let's, I will withdraw the petition, my lords.
Better to do that.
Because, my lords, she's 18 plus only, a furniture, Aadhaar card, and there is no
ಆಧಾರ್
school
ಕಾರ್ಡ್ ಅಲ್ಲಿ
records.
ಇಲ್ಲಪ್ಪ ಅದು. ಈ
School
ಸ್ಕೂಲ್ ರೆಕಾರ್ಡ್ಸ್
records
ಕೊಡಿ.
also is- I don't have, my lords, and they need to furnish, they need to do
It's
the.
part of the charge sheet. I don't know, it's the part of
ಅಲ್ಲ,
the charge sheet.
ಸ್ಕೂಲ್ ರೆಕಾರ್ಡ್ಸ್ ಆರ್ ಪಾರ್ಟ್ ಆಫ್ ದ
ಅದು
ಚಾರ್ಜ್
one
ಶೀಟ್.
page ಇದೆ, ಅಷ್ಟೇ,
ಇಲ್ಲ,
my
ಪೂರ್ತಿ
lords.
ಸ್ಕೂಲ್ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲಿ?
It's there. That is, they want birth certificate. They'll get a certificate from the school. That's all.
But
Hey,
birth
Aadhaar card with
certificate
my
from the
learned friend
school,
is
how,
lying
my
on.
lords, birth certificate should be from the
No, I understand.
concerned
ಅಲ್ಲ, ಸ್ಕೂಲ್
hospital.
ಕೊಟ್ಟಿರ್ತಾರೆ ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಂತ.
Aadhaar card, my lord,
Let
my
them
learned friend is
furnish it, my
producing.
lords.
Anyway, you want to withdraw, you
request
withdraw it.
withdraw.
Will
Let
reserve
them
the liberty.
furnish.
The petitioner seeks leave of this court to withdraw the petition and approach this court in the event of need in future. Reserving such liberty, petition stands disposed.
Oblige.
32.
ಅದು ಜಡ್ಮೆಂಟ್ಸ್ ಕೊಡಿ.
Please.
ಮಧ್ಯಾಹ್ನ ಬರೆಯೋ.
33.
ಮಧ್ಯಾಹ್ನ ಬರೆ. ಅದು ನೋಡ್ಕೊಂಡ್ಬರ್ತೀನಿ. ಎಸ್.
Opening for the petition is case.
33.
ಜೈನ್.
My lords, notice came to be issued on 4/6, my lords, when the FIR came to be registered on the very same day. I appeared before the police That notice, my lords, is incomplete without
That
appending any
35(3).
FIR. Please, my lords.
Hmm.
Now I
No,
have
no
got-
FIR copy?
No FIR copy, my lords.
Hmm.
Then I have
306.
arrested- Please, my lords.
Allegation is 306.
No, my lords.
Oh, sorry,
It's
318.
It is accused number 1 has committed theft and she has given it to me and I have given her money. I am a pawnbroker.
Pawn broker.
Please.
Hmm. Yes, ಯಾಕೆ ಇನ್ನು ಎನ್ಕ್ಲೋಸ್ ಮಾಡ್ತಾ ಇಲ್ವಾ FIR?
ಮಾಡಿದ್ದಾರೆ. The only issue is that his contention is that we should have noticed and arrested him. We arrested him because we
But
wanted to
notice
recover
is
the
that
article.
ಈಗ you are in custody?
Please, my lords.
He's in
Notice is
custody.
that
In
annexed
police
B, my lords, at page number 19.
Police custody.
Lordship, about Monday, my lord, I'll secure the entire record.
My lords, at page number 19, my lords, is the notice, my lords.
This police officer still have
ಅಲ್ಲ ನೋಟಿಸ್ ನೀವು ನೋಟಿಸ್ ಕೊಟ್ಮೇಲೆ ಅಲ್ಲಿ ಯಾಕೆ ಸಡನ್ ಆಗಿ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರಿ?
notice, my lord, he was taken to custody and there is a confusion, my lord, up to 7 years notice has to be issued.
It is mandatory.
Taken to custody and notice is issued in police station and that is what he is
That is
claiming.
not necessary.
Not necessary, that's
Well, offense is punishable less than 7 years. my
Correct.
lords. It is necessary that notice has to be issued.
Hmm.
I have to cooperate with the police for
ಅದಕ್ಕೆ
investigation.
ಮುಂಚೆನೆ ಅರೆಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರಾ?
No. I was called to the police station. Notice is
When he
issued.
did not cooperate, you should have
no,
arrested.
we are supposed to have, we wanted to arrest him and recover article from him. We have arrested him and taken custody. Receivers of stolen goods.
No. Nothing is there in the FIR. my
You are
lords.
accused number 2.
Please, my lords.
Gold of how much?
75 grams as per the FIR, my lords.
75 grams.
So not one case, there are seems to have multiple.
Against him, get the information.
That have been stayed, my lords, by this honorable court.
ಯಾವ್ದು ಕೊಡಿ? Numbers ಕೊಡಿ. Tag along with so and so, list them all on Tuesday.
My lords, is in custody.
Morning
my
fresh matters.
lords. Is in custody, my lords.
All right, yes. Bail ತಗೊಳ್ಳಿ. Bail apply ಮಾಡಿಲ್ವಾ?
It is applied on the very same day, my lords, but
Bail ತಗೊಳ್ಳಿ, yes.
My lords,
Whoever wants time, please take, because sitting is only up to 4 o'clock.
my
And
lords,
2:30 I have a part at my.
serial number 58 withdrawal, my lords, the same may be withdrawn.
Orders ಕರ್ದ್ಬೇಡ madam.
58, parties have recalled.
One more.
Yes, list 2.
Orders call out madam.
my lords. that
Wait.
bail-
Wait.
Page 7, 34 to 39.
Please, serial number 36.
ಒಂದ್ ನಿಮಿಷ ನಿಮ್ದು wait sir.
I've been in custody since 6 days, my lords.
ಒಂದ್ ನಿಮಿಷ sir. ಹಾ.
Number 36, Lordship, may grant me a week's time by senior.
34 to 39 vacating stays ಇರೋದು ಮೇಡಮ್ ಎಲ್ಲ list them all on ಯಾವ ತಗೋಣ?
My lord. My lord.
ಇವತ್ತಾಗಲ್ಲ ಮೇಡಮ್, I'll take it another day. ಇವತ್ತು only.
Number 36 was just mentioned.
Wait. 24, all 34 to 39 vacating, ಒಂದ್ ನಿಮಿಷ ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್ ಒಂದೊಂದೇ. 34, 24th,
35.
24th, 24th,
36.
24th,
37.
24th.
38.
37 people, this is on the passport issue.
My lord, serial number 36. My
36 in.
My lord, serial number 36. It's led by senior counsels. My
No
lord.
problem. 36 also on the same day, 24th. Yes.
37, my lords.
ಅಲ್ಲಿಗೆ ಬಂದಿಲ್ಲ ಸರ್, ಇರಿ ಒಂದ್ ನಿಮಿಷ.
37.
37 for respondent in this case. I filed an application for vacating.
Correct sir, ಅದಕ್ಕೆ 24th. Today it's not possible.
38.
Relaxation of direction, what direction?
24th, my lord.
ಏನ್ direction?
Sir, NDPS cases where others has to be deported.
Oh, that case
That case.
ಆಯ್ತಾಯ್ತು. Wait, ಅಲ್ಲಿ full ಆಗೋಗಿದೆ, ಇರಿ. Yes. No, 24th, yes. No, wait. ಅಲ್ಲಿ it is full sir, detention center is full. Women's, wait, ಅದಕ್ಕೆ full ಆಗಿದೆ ಅಲ್ಲಿ.
39.
30, review, 24th, yes.
40.
Seal number 40 appearing for petitioner, my lord. My lord,
ಏನಿದು 40?
my lord, it is regarding the fertilizer officer wherein license was cancelled, my lord. Despite the interim order, the FC was not allowing the company.
24th, yes.
Great, sir.
Recall the order, what? ಹೌದು ಆಯ್ತು ನೋಡೋಣ, ಇರ್ಲಿ 41 ಇರ್ಲಿ. ಎಸ್
42, my lords, for the petitioner, the respondent has not represented by a counsel yet, my lords. The notice has been,
process fee ತಗೊಂಡಿಲ್ವಾ?
we have paid it, my lords.
Land council submits needful has been done. List on 1st July.
Interim order maybe.
Interim order ಇದೆಯಾ? Then ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗಿ ತಗೋಣ. 7th July. Interim order continues. Yes.
Orders 43.
For withdrawal. ಅದು ಅಷ್ಟೇ both.
44.
For withdrawal ಅಂದ್ರೆ ಚಾರ್ಜ್ ಶೀಟಾ ಮೇಡಮ್? ಚೆಕ್ ಮಾಡಿ. Yes.
45 withdrawal.
Withdrawal.
46.
Post immediately after service of notice upon the second.
47.
Post immediately after service of notice upon the second respondent. Interim order ಇದೆಯಾ? Interim order will continue to the next date of hearing. Next. 231 andre let it, will finish it. But respondent yaru? Hearing the victim is necessary, 231 ಅಲ್ಲಿ. Yes, 46 list the matter on Tuesday in the fresh matters list. Yes, next. 2 weeks to do the needful. Post immediately after service of notice upon the second respondent.
49.
Same.
50.
My lord, in serial number 50, my lord, we were directed to take service by hand. We've already filed acknowledgement on 24/4, my lord. This is a covered matter where beyond the statutory period under 138.
List the matter on 24th. Yes. Land council submits, needful has been done. Next.
My lord, interim order may be extended.
Wherever interim orders that will continue. Yes.
Grateful, my lord.
51.
Await service.
Post immediately after service.
52.
Non-compliance. A week's time is granted to comply with the office objections.
53. Memo for
Withdrawal.
54.
Post immediately after service of notice upon the respondent.
55.
Post same order.
56.
Same order.
57.
A week's time is. Petitioner to serve the counsel for the rest. Who is complainant? Complainant by way of hand sum. Petitioner is at liberty to serve the second respondent complainant by way of hand summons. Next.
I appear for the petitioner.
Withdrawal.
Maybe withdraw.
59.
Fellows in 59 and 60. Fellows in 59 and 60, I appear for the petitioner, my lords. We are without interim in this matter, and I've been instructed that they have secured NBW from the trial court.
There is an interim order here.
No interim order.
I am without interim, my lords.
This is a GST fraud. We
No
issue
problem.
notices, he
Yes.
doesn't cooperate.
A week's time is granted to do the needful. Both. Yes. Next.
Great.
Same.
62.
Yes, madam.
Lord, item 62, Lord, I seek to appear for an intervener, Lord, de facto
1 minute,
complainant.
sir. 62 have not yet come, sir. 1 minute.
61.
Sorry.
Yes, madam. Whom have you served? The petitioner in person submits that the respondent has been served, a counsel for the respondent has been served. Who appears there, is it? All right. When do you want? 20? List the matter on 23rd. 23rd. Yes. Yes.
62.
Yes, 62.
This is that Madras.
Yes, Madras.
Lord, I seek to appear for an intervener, Lord. We are the de facto complainant. We would like to file an intervention application. The Lordship may give us 2 or 3 days time, my Lord. We'll place all the material facts.
Really?
The matter is also being monitored by a division bench of the Madras High Court, as well as there is a direction by the Honorable Supreme Court in this, my Lord.
Oh, which is the SLP?
And I'll just give the SLP.
I'll give it, Malada.
SLP and then pass over.
Documents.
I'll take it at 2:30. Yes.
Obliged.
All admission matters, wherever interim order is there, they will continue and all will come on the 24th or week commencing from 22nd. ಇವತ್ತು ಟೈಮ್ ಇಲ್ಲಪ್ಪ. ನೀವು ಇರ್ಲಿಲ್ವಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಂತೆ. ಯಾವೇನಿಲ್ಲ ಇಲ್ಲ, ಎಲ್ಲರ ಮೇಲೂ ಅಲಿಗೇಷನ್ ಇದೆ. ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾ ಇದ್ದೆ ನಾನು. ಅಷ್ಟರಲ್ಲಿ ಅವ್ರು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರು. ಅದಕ್ಕೆ ಏನು ಟಾರ್ಚರ್ ಕೊಡಬಾರ್ದು ಅಂತಿದ್ಯಾ? ಮತ್ತೆ ಎಲ್ಲ ಅಲಿಗೇಷನ್ ಇದೆ. ಬರಿಬೇಕು ಬರಿತೀನಿ ನಾನು, ತೊಂದರೆನೇ ಇಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ.
75, just one submission, item 75.
Lordship on the previous occasion had said that if respondent makes no submissions, your Lordship should be constrained to grant the interim order. This is that matter which is pending in Mysore. Could your Lordships have it? This is the DV Act proceedings. I'm challenging the entire proceedings. She has filed another complaint, fresh complaint now under 125.
But today this is not possible
Yes,
at
could
all.
your Lordships have it anytime in fresh matters? This is
Fresh matters, first time ಬಂದಿರೋದಾ?
ಇಲ್ಲ, first time admission ಅಲ್ಲಿ ಇದೆ.
Iರ್ಲಿ, we'll take it, don't worry.
But 87, my
Fresh
lord.
No, if on a given day, if it is there at 6:30, also I'll take it, don't worry.
Serial number 87, my lord.
Huh? Settlements I'll take.
My lords,
All settlements I'll
85
take.
and 88.
Madam,
Serial number
settlement
87, my lord.
settlement ಮಧ್ಯಾಹ್ನ ಕರೀರಿ. ಮಿಕ್ಕಿದ್ದೆಲ್ಲ 23, 24, 25. Divide amongst 3 days.
Serial number 87.
My lords.
ಆಯ್ತು, we'll see.
Serial number 87, my lord.
My lords, 85 and 88.
ಮಿಕ್ಕಿದ್ದೆಲ್ಲ yes. 145, sir.
87, my lord.
85 and 88.
With my,
Huh? Which is that number? Nodi?
Serial number 8.
Lord,
Serial number
serial
85
number-
and 88.
The
Particular date.
council is indisposed, my lords.
ಮೇಡಮ್ ಯಾವಾಗ ಬರುತ್ತೆ ಮೇಡಮ್ ಅದು ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್
ನೋಡಿ ಸರ್ ಡೇಟ್ಸ್ ಡಿವೈಡ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ 23, 24, 25.
For tomorrow, my lord, in this matter, my lord.
Move it tomorrow.
Swami.
Kindly, my lord, serial
ನಾಳೆ
number.
ಮೂವ್ ಮಾಡಿ.
Swami.
They are going to file a charge sheet, my lord. Respondent police are going to file a charge sheet on
ರಾತ್ರಿ
Tuesday, my lord.
ರಾತ್ರಿ ಆಗ್ತಾರ.
Tuesday ಆಗ್ತಾರಂತ ಹೇಳ್ತಾರೆ.
ಟ್ಯೂಸ್ಡೇ
Monday ಆದ್ರೂ ತಗೊಳ್ಳಿ.
ನಾಳೆ ಮೂವ್ ಮಾಡಿ ಬೆಳಗ್ಗೆ 2:30 ತಗೊಂತೀನಿ.
Serial number 33, the matter wherein within 30 minutes of the issuance of 35(3) notice, petitioner was arrested. But I have been in custody on from 4/6.
Which matter?
33, my lords. 35(3) notice issue ಮಾಡಿ within half an hour I was
ಯಾರು
arrested.
ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ? Tuesday.
Monday, my lords. Well, I'm only seeking a direction to the learned magistrate to consider my bail application.
let me ಯಾಕೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾ ಇಲ್ವಾ?
4/6 ಇಂದ every day it is being listed. It is not, they have sought 4 times, my lords.
ಬರ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ.
Your can then dispose it of. If that's a prayer, it can be disposed.
ಅಲ್ಲೇ ಹೇಳ, ಆಮೇಲೆ you can come back if there is anything.
But the illegality remains, my lords, because.
ಆಯ್ತು, wait, don't worry. Yes.
Please, my lords.
The pendency of this petition before this court should not come in the way of the learned magistrate considering an application seeking the petitioner's enlargement on bail. The learned counsel submits that the matter has been pending before the concerned court seeking bail from 4/6/2024. Therefore, the learned magistrate shall expeditiously decide it.
Please, my lords, may I request for hand delivery of this order, my lords?
Fellowship submission. Secondly, 23 dispose 23.1 ಅಲ್ಲಿ ನಾವು ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ಪಿಟಿಷನ್ 23(1) ಅಲ್ಲಿ ನೋಟಿಸ್ ಸರ್ವಾಗಿಲ್ಲ ವಿತೌಟ್ ನೋಟಿಸ್
Very good.
ಟುಮಾರೋ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಅಕ್ಯೂಸ್
Nothing. 7 ವರ್ಷ ಇಲ್ಲಿ ಸ್ಟೇ ತಗೊಂಡು ಅದರಲ್ಲಿರೋ ಫೈಂಡಿಂಗ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಟುಮಾರೋ ಮೇಲೆ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ಟುಮಾರೋ ಮೇಲೆ
ಪರವಾಗಿಲ್ಲ, ನಿಮ್ಮನ್ನ ಏನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿಲ್ಲ.
ಆನ್ ರೆಕಾರ್ಡ್ ಅಡ್ವೊಕೇಟ್
ಕೊಡ್ಲಿಲ್ಲ ಟೈಮ್ ಅಂತ ಹೇಳಿ.
Lordship, serial number 59 and 60 of list 2, my lords. Just 1 second, Elder. My lords, in that your lordships have directed us to do the needful. However, I have instructions, my lord, that everything has been complied with, my lords. We
No
may
problem.
be permitted.
If it is complied with, it will come in admission. Yes.
Please,
Only
so
one
grateful.
observation, my lords, they have not been filing their objections. 4 dates. they have
In
taken.
which?
33, my lord, serial number. Only one observation without.
Can I ask, the state, give a mandamus to the state to file objections?
My lords, only request would be without waiting for their objections.
How can I say, don't wait for the objection, pass orders?
My lords, 4 dates.
What kind of orders you ask, sir? Sir?
I'm okay.
Yes.
ಸ್ವಾಮಿ ಇವತ್ತು ಡೇಟ್ ಕೊಡ್ತೀನಿ ಅಂತ 69 ಡೇಟ್ ಇದೆ.
ಇವತ್ತು ಬಂದಿದ್ಯಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಇವತ್ತು 4 ಗಂಟೆಗೆ ಎದ್ದೇಳ್ಬೇಕಲ್ಲ?
ನಾಳೆ ಆದ್ರೂ
24ಕ್ಕೆ ಯಾವ್ದಕ್ಕೆ ಹಾಕಿದೀವಿ ನಾವು? 23ಕ್ಕೆ ಹಾಕಿದ್ದೀನಲ್ಲ.
ಆಯ್ತು.
Yes. ರಿಪೋರ್ಟಿಂಗ್ ಎಷ್ಟಿದೆ? ಅಲ್ಲ ಇದೆಲ್ಲಿ ಅದು ಶ್ಯಾಮ್ ಸುಂದರ್ ಸರ್?
Senior is held up in another court, my lords, in court all 7.
Then you tell it heard reserved.
Kindly
Right.
pass over the.
No pass over. Yes.
Let them start, my lords.
He has finished. Velan has finished. Now is your new mugsbidi. You have appeared out of the VC now. Yes. Main argument.
Main alla.
Main.
I will need 5 minutes.
Yes.
Can I?
Then wait. I'll take it at 3:15 sharp.
I'll
ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಇದೆಯಾ?
ಅಲ್ಲ ಇನ್ನೊಂದಿದೆ ಮುಗಿಸ್ಕೊಂಡು.
ಅಲ್ಲ ಮತ್ತೆ ಆಮೇಲೆ ಆನ್ ಲೆಗ್ಸ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ 15 315.
315 because 355 I will raise reference ಇದೆ. 315. 315 if he comes fine, otherwise I'll hear them and reserve it. Yes.
My lordship, I appear for respondent number 2 in this case, my lordship. The petitioner's advocate is not present before this court. Kindly have it on Monday, my lordship.
What's the offense?
424-06, my lordship.
Rest the matter Monday at 4 PM to report settlement.
Much obliged.
Ajay,
The petitioner matter settlement.
where?
In the various forums, not in the commercial court, we've withdrawn all cases. They had filed certain cases.
Illen.
My lord, here, my lord, offenses under 339.
Those settlements record this also?
My lord, yes, my lord.
Joint
One is,
memo.
yes, my lord. Joint, we filed a joint.
Bani,
And the petitioners were also.
where is the settlement?
My lord, we have filed it.
Yes, closed. Next.
Grateful.
Offense in?
No, 339, my lord.
Yes, next.
Great.
Pratik,
Respondent, my lord, matter is settled before the Delhi High Court. My lord.
Matter has been settled. They filed the joint affidavit.
yes, fine.
It's filed.
ಎಲ್ಲಿದೆ ಫ್ಲಾಗ್ ಇದೆಯಾ ಮೇಡಮ್? ಇದೆ. Parties?
The party, the
ಅಲ್ಲಿ ಆಗಿದೆ
petitioner,
ಅಲ್ವಾ?
senior counsel.
In Delhi, it has been settled, my lord.
Yes.
The memo has been filed.
Memona?
A joint settlement.
Joint settlement, yes. Parties are present ಅಂತ ಹಾಕ್ಬೇಡಿ ಅಷ್ಟೇ. ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಕೋರ್ಟ್ ಮಾಡಿ.
Grateful. No, 498 and 306.
306, sir?
Yes, ma'am.
Why, sir?
There is no any, my lord, the ingredient.
498 306.
498 306. No means free, my lord. No death note, my lord. Law complaint lodged by the, my lord, the brother of.
Husband also?
Brother of the, my lord, sister complaint lodged against the, my lord, the.
No, who is accused number 1?
Husband.
Where he is not?
He is there.
No, I don't want him, but he is also party to the settlement now?
Yes.
What
Complaint
is it?
also present.
For respondent number 2.
Abetting suicide, yeah, husband abetting wife suicide.
Yes, my lord. Complaint, my lord, is the brother.
In marriage date of 1 year, 1 month.
304B alva?
No, my lord. 498 306.
Come on, merits. Yes, list the matter on 19th. Yes.
Obliged.
No settlement. Come on, merits will decide. Next, yes.
The petitioner settled your both parties is present your
Offense?
Fox your 18 years marriage ಆಗಿ ಮಗು ಇದೆ ಸ್ವಾಮಿ ಹಾಸ್ಪಿಟಲ್
ಯಾವ ಮ್ಯಾರೇಜ್ ಏಜ್ ಏನು?
17 years 9 months your honor ಈಗ 19 years ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
ಮದುವೆ ಆಗಿದೆ ಯಾವಾಗ?
26 25
ಹಾ?
26 2025
26
2025 your
2025 18 ಆಗಿತ್ತಾ?
ಎಸ್ your
ಅವಾಗ?
ಅವಾಗ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಬಟ್
ಮದುವೆ ಆದಾಗ ಆಗಿರ್ಲಿಲ್ವಾ?
ಮದುವೆ ಆದಾಗ ಆಗಿಲ್ಲ.
ಮತ್ತೆ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ?
ಮಗು ಆಗಿದೆ ಸ್ವಾಮಿ ಮಗು ಆಗಿ
ಅದು ಸರ್ಟಿಫಿಕೇಟಾ?
ಅಲ್ಲ ಜೊತೆಯಲ್ಲಿ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ಅದರ ಟೆಂಪಲ್ ಅಲ್ಲಿ ಮದುವೆ ಆಗಿದ್ದಾರೆ.
ಹಾ.
ಸೊ ಮಗುನು ಕೂಡ ಆಗಿದೆ ಈಗ.
ಸರಿ, ಈಗ ರಿಜಿಸ್ಟರ್, ಗೆಟ್ ಇಟ್ ರಿಜಿಸ್ಟರ್ಡ್.
ರಿಜಿಸ್ಟರ್ ಇವರ
ಮಾಡ್ಬಿಟ್ಟು ಬನ್ನಿ, ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬಿಟ್ಟು ಬನ್ನಿ.
ಅಲ್ಲ ವಾರಂಟ್ ಇದೆ ಸ್ವಾಮಿ, ಟ್ರಯಲ್
ಪರವಾಗಿಲ್ಲ, ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬಿಟ್ಟು ಬನ್ನಿ. ವಾರಂಟ್ ನಾನು ಸ್ಟೇ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ, ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟೇ ಮಾಡಲ್ಲ.
ಬೇಡ
ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ, ಆಮೇಲೆ ವಿಲ್ಸಿ. The parties to the list, the issue in the list is with regard to the offences punishable under the POCSO Act. The learned counsel for the petitioner submits that the petitioner, accused number 1 and the victim have got married, and would produce the registration of such marriage on the next date. A warrant is hanging on the head of the accused number 1, therefore the same shall remain stayed till the next date of hearing. List the matter on July 3rd.
My lord, kindly fix the date on the 19th, my lord. Both the parties will be present.
19th, 4 p.m. Next.
125A of BNS, your lordship. It's 337. Settle the matter. Complainant.
Yes. Next.
One submission, your lordships. ಇದರಲ್ಲಿ ಕಂಪ್ಲೇನೆಂಟ್ is ವೆಸ್ಟ್ ಬೆಂಗಾಲ್ ಅಲ್ಲಿ ಲೋಕಲ್ ಅಡ್ವೊಕೇಟ್ ಹ್ಯಾಸ್ ಕಮ್.
Sorry?
ಕಂಪ್ಲೇನೆಂಟ್ ಪ್ರೆಸೆಂಟ್ ಇಲ್ಲ, ಬಿಕಾಸ್ ಈಸ್ ಇನ್ ಹಾಸ್ಪಿಟಲ್. ಇದು ಮನೆಯಲ್ಲಿ ಇದ್ದಾರೆ,
ಹಾಸ್ಪಿಟಲ್ ಇದೆ.
ಅಲ್ಲ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲ, ಮನೆಯಲ್ಲಿ ಇದ್ದಾರೆ, ರೆಸ್ಟ್ ತಗೊಂಡು ವೆಸ್ಟ್ ಬೆಂಗಾಲ್ ಅಲ್ಲಿ.
ಮನೇಲಿ ರೆಸ್ಟ್ ತಗೊಂತಾ ಇದ್ದಾರಾ?
ಅವರಿಗೆ ತಾಗಿದ ಕಲ್ಲೇ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ ಅವರ ಲೋಕಲ್ ಅಡ್ವೊಕೇಟ್ ಇಲ್ಲಿ ಬಂದಾರೆ ದೊಡ್ಡಬಳ್ಳಾಪುರದಲ್ಲಿ ಇನ್ಸಿಡೆಂಟ್ ಟು ಐಡೆಂಟಿಫೈ ಹಿಮ್. ವಿಡಿಯೋ ಕಾಲ್ ಮಾಡಿ ಇದು ಮಾಡ್ಬೋದು, ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ರಿಮೋಟ್ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ.
We'll take it after 4 weeks, no problem.
Please, your lordships.
We'll take it after 4 weeks. Our rest period ಮುಗಿದ ಮೇಲೆ ಬರಕ್ಕೆ ಹೇಳಿ. Yes. List after 4 weeks.
My lordship, the parties were unable to attend today. Kindly
19th?
Tomorrow, my lordship.
Tomorrow? No. 19th?
Okay.
ಇಲ್ಲ ಮಂಡೇ ಬೇಕಾ?
Monday. Okay, Monday.
Monday, yes. Monday 4 p.m. report settlement.
My lordship, petitioner and respondent number 2, husband and wife.
ಏನು offense?
Offense section 115 subclass 2 and 69 of BNS. ಮದುವೆ ಆಗಿದೆ, ಮ್ಯಾರೇಜ್ ರಿಜಿಸ್ಟರ್ ಕೂಡ
69.
69.
Promise to marry.
ಹೌದು, ಮದುವೆ ಆಗಿದೆ.
ಮದುವೆ ಯಾವಾಗ ಮಾಡಿದ್ರಿ?
16th March.
ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದೀರಾ?
ಆಗಿದೆ ಸ್ವಾಮಿ.
ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆಯಾ?
ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ, ಫೈಲ್ ಅಲ್ಲಿ ಕೂಡ ಹಾಕಿದ್ವಿ, ಕಾಂಪ್ರಮೈಸ್ ಡೀಡ್ ಕೂಡ ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ.
ಆಯ್ತು. You have fulfilled the promise. Yes.
And another connected matter next 108.
ಎರಡೂನಾ?
ಸೇಮ್ ಸ್ವಾಮಿ.
ಅದು ಯಾರ್ದು?
ಒಂದು ವರ್ತು ಸ್ಟೇಷನ್ ಅಲ್ಲಿ
ಇಬ್ರು ಪ್ರಾಮಿಸ್ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಒಬ್ರೆ ಸೇಮ್ ಇವ್ರೆ. ಒಂದ್ ನಿಮಿಷ ರೀ. ಒಂದು ವರ್ತೂರ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ FIR ಆಗುತ್ತೆ ಸ್ವಾಮಿ, ಇನ್ನೊಂದು ವೈಟ್ ಫೀಲ್ಡ್ ಅಲ್ಲಿ ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
ಒಬ್ರೇ ತಾನೆ?
ಒಬ್ರೇ.
ಓನ್ಲಿ ಪರ್ಸನ್, ಓನ್ಲಿ ಪ್ರಾಮಿಸ್. TD petition ಅದೇ ಮೇಡಮ್. ಎಸ್. ಇಲ್ಲಿ ಇಬ್ರು ಇಲ್ಲೇ ಇದಾರಲ್ಲ? ಒಂದ್ಸಲ ಏನ್ ಬೇಡ, ಮದುವೆ ಆಗಿದಾರ. ಅದಕ್ಕೂ ಅವರೇ ಬರ್ಬೇಕೇನೋ. It's music.
It's please. Seniors engagement notes, it may be passed over, please note.
ಪೇಜ್ ಇಲ್ಲೇ ಇದ್ದೀರಾ? Oh, sir, yes. Hmm.
It may be passed over, please, my lord, senior.
Let him come, please.
110 is that the DRDO, my lord, the complaint was against 3 unknown
Dogs.
people.
Dogs.
Yes, DRDO officer is arraigned as the accused, but the complaint says 3 unknown people.
Now, who's the complainant here?
BBMP.
Complainant, who's Navina Kamath? Party in
I'm Navina
person.
Kamath.
What's this? You are the complainant.
No, I am the intervening.
Right, yes. Intervening applicant, is it?
Yes.
Why do you want to intervene here?
So I have seen that there has been a blatant and contemptuous violation of the existing laws and statutes under the framework of the ABC rules, the PCA Act, and several directives of the Supreme Court in SLP 691 of 2009. So BBMP or GBA is the only authority which is vested with powers